May I please I mentioned for answer listing motion item to them. But my diagnostic center is proposed for the sale tomorrow. Obliged. Not another two motion item for Friday. Obliged.
May I please, Your Lordship, with respect to item number 63, we have filed our additional.
But, Mr. Bhuya, try to bring it before 2 p.m.
Yes, my lord, I'll try my.
because 2 p.m. I have another set of matters.
Fine.
With item number 63, Lordship, record may be called for it.
Item number?
63, Your Lordship.
What is this?
Obliged.
For withdrawal.
Friday. Friday.
Item number one is motion.
Before that, madam, I have a pending matter, madam, settlement of plan. Premium has been given, madam. Premium, sorry, madam, premium has to be given, madam, it's calculated, madam. Plan has been in the possession from the last 30 years, sorry.
Now what do you want?
Madam, any date, madam, 19, madam.
You have come late. Mention it tomorrow. Why? Who is your senior? Where is he? What is the prayer?
Annual action plan was prepared without conducting the town sabha.
PNRD? No PNRD?
No. No fear.
In this matter, you are only appearing. You are Mr. S.J. Sharma. Then, why are you asking for a senior?
That was prepared without conducting the town.
Huh?
That was prepared without conducting the town sabha.
Yes, Mr. Dotto, what is your instruction?
My lord, instruction not yet received, my lord. Our lordship may run some time. I will take it, sir.
No. I think we issue notice.
That is.
Issue notice returnable on 9th of March 2026. Mr. S. Dotto, the Standing Counsel of the PNRD Department accepts notice on behalf of the respondent numbers 125, 1257, 125, 8, 9, and 10. Why you are making the secretary you have already made? Why you are making 7 unnecessarily the president? Mr. So-and-so appears on behalf of the respondent number 6.
Eight months.
Full stop.
Only six.
Taking into account that the respondent numbers 1 to 6 and 8 to 10 are duly represented by the respective councils, extra copies of the writ petition be furnished by tomorrow. As regards the respondent number 7, the petitioner is directed to take steps by way of speed post
One.
by tomorrow.
So finance, four.
The petitioners herein are, who are you? Are members of ward number 1 and ward number 5 of Chandpur, Boliapar Gaon Panchayat in the district of Hailakandi. The grievance of the petitioner herein is that various development schemes and plans under the scheme Amar Ahom Amar Asoni are required to be approved by the Gaon Sabhas. But the president and the secretary of the Gaon Panchayat in question, that is, the Hailakandi Gaon Panchayat,
So.
have prepared and submitted the action plan on 29/11/2025 for the year 2024-25 without conducting the Gaon Sabhas. It is on the such allegations the instant writ petition is filed. The respondent herein are directed to apprise this court by way of an affidavit to be filed on or before 2nd of March 2026 as to whether the action plan dated 29/11/2025 for the year 2024-25 have been prepared, have been submitted by the president and secretary of the Gaon Panchayat without conducting the Gaon Sabhas. Full stop. Further to that, the respondent number 8, under whom it will be, respondent number 10
My lord.
shall also prepare a report in that regard and place it before this court on the next date without fail. You are appearing for whom? There's no finance. Okay. What is R4?
Joint Director of Finance.
Finance, my lord.
Finance is there. Okay, finance could be.
How?
Okay, what is it? Silo Amar Homna. What is this case?
Hello.
Fantastic. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to withdraw the instant writ petition, taking into account the instant contempt application. Accordingly, the contempt application stands closed in view of the fact that there has been no notice issued till date. What is this?
There, my lord, I was directed to seek instructions, my lord. But I have not received an extra copy of the writ petition, but will kindly accommodate me for.
No. We do one thing, we issue notice. Without issuing notice, how can you obtain instructions?
Because they say, my lord, they are in occupation of a part and parcel of land since a prolonged period.
Wait.
which has not-
Let him say first. Here's what is your case.
Was engaging like a pottery making and the after they were at some land in the year 97. They are often finds a page number.
Page number?
20.
Yes. So this is a area for cancellation of annual leaves.
Earlier, whoever it went, my lord, and thereafter, if the lordship stand is found. So my lord, page 36, that is the my lord.
Page?
36. That is the copy of the last, my lord.
Yes. Hira land industry.
Yes.
Then what do you want?
This particular piece of land is given to someone else.
What show cause notice you have? You are entitled to?
My lord.
What show cause notice? It is only reserved.
Yes.
What is the show cause notice you are entitled to?
My lord, there, my lord, each community, public there, my lord, and there, my lord, that is the only mode of, my lord, profession and there, my lord, livelihood, my lord. Now, my lord, in the last 50 years, we have been doing that.
Are you, any steps are being taken for eviction?
Yeah,
Where?
they have been given to somebody else, my lord, that these people, my lord.
Where?
Losses fines.
What basis you say that this is being reserved for Hira industry? Then
At page number 20, itself, my lord.
I am directed to say that the governor of Assam is to approve the proposal for cancellation of 2022. And on the grounds that the land are required for public purpose, that is for reservation of clay for the potter, the taking of earth from the area will however be regulated by 2022.
So now this is the minutes dated 9/8/2023.
Yes.
I know.
That's page 40.
Yes, sir.
Now what is this?
By which 90% of the land, the same land on which was under our occupation, has been allotted in favor of some other minor cooperative society minor. And now, my lord, because of that, these cooperative society members, they have come and minor stopped us and restrained us from carrying on our works, which is our livelihood, my lord.
How? Have the allotment happened, Mr. Borbuzari?
My lord,
Mr. Borbuzari? Without an allotment, can this cooperative society do anything?
minutes of meeting otherwise has, the decision is recorded pursuant thereto whether any formal allotment letter has been issued, my lord. We'll have to seek instructions, my lord.
So unless there is an allotment being made,
Yes.
nobody can disturb anybody's possession.
No, otherwise the plot of
Once it
land-
is allotted,
Yes.
then they may have a right. But if they have a right, if these people are in occupation, they have to be thrown out by following the due process.
No,
That's the law.
yes, now the plot of land still retains the character of a government land. which
There's no
was-
quarrel with that proposition.
Yes.
But if these people are in possession,
Yes.
you can't disturb without following the procedure established by law. That's all.
Now, my lord, I have come to know that the other day, my lord, there were lots of policemen and other people coming, my lord, and repairing this, my lord. They have even not arrested the interim order that was passed by this court.
Are you in occupation of this land?
Yes. Yes.
They say they are in occupation, my lord.
Okay.
The lordship
So
will-
maintain the status quo as regards possession.
And the activity of, if
Huh?
I'm not allowed to work there, my activity is there, my lord. If I'm not allowed to work, my lord.
Issue notice making it returnable on 13th of March 2026.
So, do you know, you know,
Corporation Department,
see? You have to verify the minutes.
no corporation. Mr. Arbo Pujari appears on behalf of the respondent number 2
Two, my lord.
and you appear for respondent number 3. Taking into account that the Corporation Department is not represented, though they have a standing counsel. This court therefore directs Mr. So-and-so, who is a state government counsel, to accept notice on behalf of the Corporation Department. Extra copies of these petitions be served upon the learned counsels who appear on behalf of the respondent numbers 1, 2, and 3 during the course of the day. As regards the respondent number 4, steps be taken by way of speed post. In addition to that, the petitioner is also directed to effect service upon the respondent number 4 by way of dusty, routed to the registry of this court and file an affidavit of service on or before the next date. Pusto. The service be effected upon the respondent number 4 by way of dusty on or before 18th of February 2026. Pusto. The petitioner herein is a cooperative society engaged in the manufacture of clay products. Pusto. They have been residing over a plot of land. Where? Which land? Land measuring?
Page 20, my lord, 38 bigha, 15 lesser,
Page 20.
my lord.
They are, the petitioners herein claim that they are residing over a plot of land at measuring 38 bighas, 0 katha, 15 lechas. Huh?
7 feet. It's 30 feet.
Possession of
First column number of the cheetah, 87 number.
87 bighas, 2 katha, 16 lechas of dag number 182 of patta number the dag number 182, which is admittedly a government land. It is the case of the petitioner that as far back as on in the year 1967, the land presently under the occupation of the petitioner were reserved for the persons for whom the petitioners represent. And this aspect is apparent from the fact that in the Chita copy of dag number 182 of village Konidal, lot 7 under Moza Lokrai, within the revenue circle Sipsagar,
No, my lord.
Sipazar, in the district of Darang. The said lands have been shown to have been reserved for Hira land industry. The grievance of the petitioner herein is that the petitioners have also sought for settlement of the said lands. However, the same have not yet been considered. On the other hand, the state level subdivisional land advisory committee in its meeting dated 9/8/2023 have given a recommendation that 256 bighas 1 katha 0 lesser, which includes the land for which the petitioners have sought for allotment, be allotted to the respondent number 4. Full stop. There is nothing on record as to whether the recommendations so made by the Subdivisional Land Advisory Committee in its meeting dated 9/8/2023 have been given, have been acted upon. The petitioners who came to learn about the said submitted a representation on 12/5/2025 before the District Commissioner, Dorong. It is the grievance of the petitioner that the same have not been considered. On the other hand, the members of the respondent number 4, members of league representatives of the respondent number 4 are threatening the petitioners. It is under such circumstances the instant writ petition is filed. Mr. So-and-so, Arbor Pujari, the learned standing counsel of the Revenue Department, shall apprise this court on the next date as to whether the recommendations were made by the Subdivisional Land Advisory Committee favoring the respondent number 4 in its minutes, in the minutes of the meeting held on 9/8/2023. Minutes of the meeting held on 29/7/2023 have been given effect to by the respondent authorities. Full stop. This court also, full stop. Mr. G. Chaudhary, appearing on behalf of the petitioner, submits that the members of the petitioners association organization, what is that? Society, are presently in occupation of the said lands and are carrying on their business. The business is being hampered at the behest of the respondent number 4. Full stop. Considering the above, if the petitioners are in possession of the land in question, comma, the comma, they cannot be disturbed or evicted without following the procedure established by law. Accordingly, this court, therefore, however, this court cannot also ascertain as to whether the petitioners are in actual possession. Accordingly, this court directs that till the next status quo as regards the possession be maintained in respect to the land mentioned in DAG number 182 of village ekita koi disu, village so and so, lot number 7. Full stop. This court, for the sake of clarity, observes that the directions to maintain status quo would further permit, if the petitioner, members of the petitioner's society are in possession, to carry out their day-to-day activities.
My lord had issued formal notice, my lord.
Yes.
Sir, we had initiated taking steps, my lord, even on the respond number 4. So now we take fresh steps for that is sufficed, my lord.
What?
We had taken steps earlier on all the respondents and even on the respond number 4 by people. That gets reflected.
You don't want to take steps?
No, then.
Okay, cut it off. You don't want to, we dismiss your petition. No, Mr. Counsel, without a notice, what is this steps business? I don't understand. Very good. Follow that. And there was no interim order. There was no interim order. That interim order has ceased to exist. If you don't take steps, if the steps are not being done as directed above, within 3 days from today, the order so passed herein above shall not hold. Don't come up with unnecessary media. Last line to Nalag.
Last state, my lord, responding with instruction as regard to repair.
What is your case? Forget about what is the instruction sought for. I'll ask them the instruction later on.
My father has purchased this particular plot of land and after he decides that about that land. And I am residing therein and I have a.
You are in possession of which DAG? DAG number 78.
70. 78.
What is the patta number? Huh? Where is your patta?
Page number 5.
Huh?
Page number 5.
What is page number 5? In the petition?
Yes.
What is that?
It is written in there. Third bench.
So there you have not enclosed any document. So why should we believe that you are the owner of the land? Are you prepared with your case or not? Are you prepared with your case or not?
That document.
When a matter has been taken up, the counsel appearing on behalf of the petitioner is not prepared. List the matter after 2 weeks. Dated of its school. This is not This is not what we expect, Mr. Counsel. You have to be prepared when the matter is before them. Don't expect that they are going to obtain. Absolutely no. There is a document. It doesn't take me for me to find out in 2 minutes. There's a sale deed. Are you not in a position to show that? Then you should be prepared with your case, Mr. Counsel. Don't come up before this court unprepared. Absolutely unbecoming of a counsel. We'll take your matter at 4:45 if you want. Prepare yourself by the day. Don't come up before this court. Yes, what is your case? Why? Where is it paying for which department?
I'm appearing for one lordship. Instructions. Instruction and what is lesson?
Yes. He had filed an application under section 64.
That has to be heard.
Why haven't you taken any action? It is only required to be referred to.
It has to be.
Why haven't you referred it? We dispose it of,
Yes.
along his petition.
He has filed it
One application.
on October probably.
Obviously, it is the saddest part of this that you don't have an instruction in spite of the fact that this court had asked for you for the instruction.
That has not come.
The simple aspect. Heard? What is your name? So and so, the learned counsel appearing on behalf of the petitioner. Ms. So and so appears on behalf of the Revenue and Disaster Management Department. Mr. So and so appears on behalf of the respondent number 2, 3, 4, 5. The grievance of the petitioner herein is this court take the issue involved in the instant proceedings. In the opinion of this court can be disposed of at the motion stage. Accordingly, the instant writ petition is taken up for disposal at the motion stage. The issue involved in the instant writ petition is that land of the petitioner. Measuring land of the petitioner at measuring 1 biga 2 katha 10 lecha covered by dag number 224/130 of patta number 34 of Revenue Village Sirakuta, Part 1 under Sopor Revenue Circle in the district of Dhubri. Have been acquired in connection with LA case number 2/2025-26. A notice was issued bearing number 245, wherein against the total plot of land at measuring 5 biga 3 katha 11.15 lechas, an amount of rupees 1,39,83,845 have been awarded. Full stop. The grievance of the petitioner herein is that the award insofar as the petitioner's land is concerned is inadequate. And under such circumstances, the petitioner on 31/10/2025 submitted an application under section 64 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 for enhancement of the award in connection with the award number 245 LA case number 2/2025-26. The said application, which is filed on 31/10/2025, have not been taken into consideration by the respondent number 2. Resultantly, the petitioner submitted a reminder. Resultantly, no. Not really, have not been taken into. Being aggrieved, the petitioner therefore has approached this court by filing the present writ petition. Full stop. This court, it appears from the materials on record that on 21/1/2026, this court sought for instructions. However, no instructions have been placed. Full stop. Considering the fact that the petitioner has submitted an application seeking reference in terms with section 64 of the Act of 2013, it is the incumbent duty upon of the respondent authorities, more particularly the respondent number 2, to take effective steps in terms with section 64 of the Act of 2013. Full stop. Accordingly, this court, therefore, as the respondents have failed to do so, this court, therefore, is of the opinion that certain directions are required to be passed. Accordingly, the writ petition stands disposed of with the following observations and directions. The respondent number 2 is directed to forthwith, upon receipt of a certified copy of the instant order, make a reference in terms with section 64 of the Act of 13 in respect to the application so filed by the petitioner on 31/10/2025. Number 2, it is further observed, for the sake of clarity, that in the circumstance that in the meantime the reference has already been made, there shall be no, the direction so passed in clause number 1 herein above need not be complied with. Number 3, the petitioner would be at liberty to accept the amount as mentioned in the notice under protest and without prejudice to the application so filed by the petitioner on 31/10/2025. Anything more? Sure. What is this?
Lordship, I'm praying for a short passover since the
Why?
Lordship, the standing council.
What is your case?
Let's do, the cancellation of GST registration.
Why?
Cancel in the year 2021.
Why should we exercise our 2 to 6 powers?
Why, what is the revocation under section 30, madam? That application was also filed before the authority was rejected by. Thereafter, my lord, for filing appeal under 107, your lordship. After a specific time limit, my lord, there is no power to condone this.
No, the moment it is rejected, isn't it a fresh cause of action? Then why didn't you file an appeal then?
What happened at that time, my lord?
What is the business you are carrying on?
Tea business and
Huh?
tea business.
Tea. So how are you carrying on your business
Right now, we are not ten.
from 2021? So you have not submitted any returns.
Because the return was not submitted, my lord.
Why?
6 months. At that time, my lord, directors, there was some dispute among the directors and all. my lord. Now we
So what is
notified-
your ground on which this court should act? Okay, let us forget about the limitation and anything, but what is the ground on which this court should act? There was an infraction of issuance of the so cause notice.
My lord, in the revocation, it was.
Forget about the revocation, the so cause, what is wrong?
They are saying, my lord, except my lord, page 32 of the document.
Where is the so cause?
Page 32. Not, yes, page 32.
Furnished by you under section. So this is the show cause.
Fine.
You submitted a reply.
We have not submitted, but they are saying that on the, since reply is not satisfactory. That it was not submitted at all.
Chalo. Where is my judgment? We allow his petition to that extent. He will pay all this.
Mine.
This is covered by a judgment of mine. You want your name or your senior's name?
Senior's name.
Is there within the
he's-
four corners of the High Court?
Yes, Your Honor.
Where?
Court number 18. Court number 18.
Court number 18. Okay, before my dictation is over, I hope he comes. Else your name. You do one thing. You need not do anything. Go and search him and ask him to come over. That is the assistance you provide to this court. Go.
Yes, well.
Because it is covered, I'll have to pass an order. So when I'm passing an order, in the meantime, ask your senior to come over. Heard Mr. A. Goyal, the learned counsel, appearing on behalf of the petitioner. And Mr. So-and-so. That is oblique I'm putting, huh? What is your name?
A Pradhan.
To oblique rakibo. By the time it finishes, if he doesn't come, then it is your name. Appears on behalf of the respondent numbers 1 to 4. The petitioner herein is aggrieved
No.
by the
S. Chitya. Suman Chitya.
cancellation of its registration in terms with
Senior.
section. What is the section?
Section 29.
Huh?
Section 20.
29 of the Central Goods and Service Tax Act 2017. Pustak. The petitioner thereupon filed an application seeking revocation of the cancellation of the registration on 10/11/2021. However, the said application was rejected on 18/11/2022. It is under such circumstances the petitioner had therefore approached this court by filing the instant writ petition. The materials on record reveal that the petitioner herein is a company registered under the provisions of what? Companies Act 1956. No, 2013. Full stop. The petitioner have obtained a registration under the Central Goods and Service Tax Act 2017 and was provided with the GST IN/unique ID bearing number 18 AAA CC 843-6H1ZL. Pusto. On account of non-submission of the returns which is required in terms with section 39 of the Act of 2017, which the petitioners do not deny in the instant petition. A show cause notice was issued on 2/9/2021, asking the petitioner as to why his registration should not be cancelled. In addition to that, it was also mentioned that his registration would stand suspended from 2/9/2021. Pusto. It is the case of the petitioner that the petitioner did not receive such notice, but and also did not file any reply. On the other hand, it is seen from the order dated 7/10/2021 that the petitioners reply dated 3/10/2021 was found to be not satisfactory, and accordingly, his registration was cancelled on the ground that the petitioner did not file the due return since October 2020. The record also reveals that the petitioner herein had sought for revocation of the cancellation of the registration by filing an application, which was, however, rejected. In this regard, this court finds it very pertinent to take note of that the issue involved in the instant proceedings is no longer res intriga, taking into account that this court have already dealt with similar issues. In the case of Motaleb Bhuiya versus State of Assam and others, which is reported in 2025 SCC Online, 2025 6 GLR, page 79. SCC Online কই দিব 2020 SCC Online GAU 1429 or /oblique Pusto. It is the opinion of this court that similar directions which have been passed at paragraph number 50 of the said judgment can be incorporated in the instant proceedings. Pusto. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The order of cancellation of registration dated 7/10/2025 21 is set aside and quashed. Number 2, the petitioner herein is directed to file the returns for the period from the date from October 2020 till date, within 30 days from the date of the instant order. The period as stipulated in section 7310 of the Act of 2017 shall be computed from the date of the instant judgment, except for the financial year 2025-26, which shall be as per section 44 of the Act of 2017. Next, the petitioner herein also shall be liable to make payment of the arrears, that is tax, penalty, interest, and late fees.
Lord.
Your name?
My lord, I'm sorry, my lord, I was in another court, lordship.
S. Setia.
Deeply obliged.
Yes, Mr. Pinak.
Lordship, I have filed this case.
Jeka What is the case about?
What will save the
Directing the so the authority, they issue the non-sale permission, NOC, well, the land that's so and so under remand, why it should not be directing to dispose of the application forfeit?
Well, we are probably
When did you submit your application?
under Seva Setu.
For permission?
On May 26, 2025.
Then why you are saying that respondent should not be disposed of the application of the petitioner 5-2?
I have an application for in page number 30. If they have not given, I have another application.
Yes, what is your instructions?
Also, they say that unless the Seva Setu acknowledgement number is given,
Huh?
they are unable to track down
Unless,
the number in Seva Setu. It is there in the read petition. I have seen in paragraph 5, it is there.
then,
And read petition was also sent along with the communication, but
then,
Lordship, I'll have to take instruction.
what is this new Guwahati co-district?
I think some code districts are created, my lord, some,
Is it?
yes.
I've never heard that. How many?
It is
Guwahati-
recently, it is.
How many Guwahati, how many co-districts are there in Guwahati?
Kiman ase na? Two.
6.
Hmm.
One must be New Guwahati, one must be Guwahati, one must be another. Dispur must have also been divided. I think as per the legislative assembly, they must have done it. Is it something like that? So nowadays, the legislative assembly, the earlier is Guwahati constituency, although it has been, it has resulted in many other aspects, but has now been declared to be a new Guwahati.
The constituency. man,
East
yes.
Guwahati is now, your constituency will be New
It is
Guwahati now.
New Guwahati.
Ah,
Earlier it was East Guwahati.
But the other part would fall in Dispur, beyond Guwahati College or something, falls in Dispur or Dimoria. Dimoria, na? Dispur is there, Dimoria is there. Dispur has been bifurcated into two. So one is Dimoria and Dispur. Guwahati is there. Then you have Old Guwahati. West Guwahati is Old Guwahati. It's Old Guwahati or Guwahati, I don't know. Then Jalukbari is also different. That is Central Guwahati, na? Yes, revenue. Expert revenue council. Dispur and Jalukbari. What happened to Guwahati West? That has become a part of New Guwahati.
Jalukbari. it has to be.
No, Jalukbari already has.
District.
Ah.
One is Dimoria, Dispur, New Guwahati, Central Guwahati and Jalukbari.
Ah.
5.
So that has become Central
And
Guwahati.
the GS Road, western side falls under the Central Guwahati. Now my house is down in Central Guwahati. Earlier I was in East Guwahati.
You are in New Guwahati.
And eastern side, GS Road, eastern side falls in the New Guwahati.
Yes.
So Ganeshguri onwards falls at Dispur.
So now we have to write differently. District Commissioner here.
District Commissioner, he is under.
Now Kamrup Metro is not there.
Well,
Kamrup Metro is not there.
Kamrup Metro is there.
Yeah.
But there are some core districts are created. No? Under District Commissioner. I'm told that they are under District Commissioner. Some core districts are.
Okay, so those additional DCs, district commissioners now have become co-district commissioners.
created.
Okay, so they have been given more power
In a-
so that they can manage their own. And overall, it will be the district
in the
commissioner.
territory.
Okay. But how do you take care of section 21A in that perspective? That a permission has to be given by the district commissioner. Isn't it 21A? What does it say? Where is 21A?
Permission has to be given by the District Commissioner.
Hmm?
But possibly when it falls within that.
Because he is asking for the deputy commissioner, district commissioner.
District Commissioner. 21 8 to the district commissioner will require it. Permission to has to be applied to the district commissioner. Ah,
Now, we issue notice getting it returnable on 23rd of February, 27th of February. Issue notice making it returnable on 27th of February 2026. Mr. Ms. So-and-so accepts notice on behalf of the respondent number 1. Mr. So-and-so accepts notice on behalf of the respondent number 2 and 3. Extra copies of the petition be furnished during the course of the day. The grievance of the petitioner herein is that the petitioner have sought for a sale permission, which is required in terms with section 21A of the Registration Act 1908 insofar as the same is applicable to the state of Assam. The said application was filed as far back as on 23 when 23/6/2025, and in that regard an acknowledgement was also issued upon being filed in the Seva Setu portal bearing number NOC/28/58524/2025. Taking into account that the said permission was not accorded, the NOC was not issued, which otherwise was required to be done within the period as mentioned in section 21A of the Registration Act 1908. The petitioner further submitted a representation before the respondent number 2. The said representation having not been taken into consideration and the NOC so sought for by the petitioner having not been issued, the petitioner is constrained to approach this court by filing the present petition. When the matter was listed before this court on 31/2026, this court sought for instructions in pursuance thereto. Instructions have been placed by Mr. B.J. Talukdar, the senior counsel, assisted by so-and-so appearing on behalf of the respondent number 2 and 3, that the NOC serial number applied in the Seva Setu portal is necessary for tracking of any pending land sale proposal, as the service for issuance of NOC for sale permission is accepted only in online mode. The said instruction is kept on record and marked with the letter X. This court inquired with Mr. B.J. Talukdar, the learned senior counsel, as to whether the copy of the writ petition was provided to the respondents, taking into account that by the order dated 31/2026, there was a direction upon the petitioner to provide extra copies. Mr. B.J. Talukdar, the learned senior counsel, submitted that the copy of the petition was also forwarded to the respondent number 2 and 3. So it shocks and surprises this court on the instructions so provided as kept on record and marked with the letter X, taking into account that the application containing the application acknowledgement has been enclosed as Annexure 5 to the writ petition, wherein the acknowledgement number is mentioned. Under such circumstances, the respondent number 2 is directed to apprise this court as to why there is a delay in issuance of the NOC on the next date without fail. It is further observed that the issuance of notice in the instant proceedings shall not bar the respondents in the meantime to provide the NOC to which the petitioner applied as far back as on 23/6/2025. Yes, Mr. Sheikh, what is it?
Notice of common land,
Thereafter, after allotment, we applied for settlement. Five notification, 11/11/2020. It is that my lord, acknowledgement were issued. But during pendency of our settlement petition as well as in operation of the allotment order, my lord. But there is a beginning of eviction.
Who says?
But they visited our land, my lord.
Where is your notice?
My lord, eviction notice is not given,
Then
but they visited, my lord. your
it's
land
like an
and-
anticipatory bail.
Yes, I, now it is not.
Mr. Seg, it appears like an anticipatory bail application.
Not to consider. Roti district, my lord. Roti is
Make this type of stuff.
What is happening, my lord? Without notice, my lord. When eviction is not. That is our apprehension, my lord. Let them produce instruction, my lord. That whether they attempted to evict. This is not, my lord, that.
First of all, is there a time period provided within which time the allotment process would be over?
That acknowledgement letter itself mentioned, but I barely submit before your lordship. A provision for appeal is provided. I have not filed that appeal. I failed to file that appeal. That is there.
No, the thing is like this. One application is filed on 10/1/2025. The other is on 10/4/2023. And the other three are December 2025. And you expect the government to give you the allotment on that day itself so soon. For 2023 is okay. But what about the 2025 December? No right cause of action.
Your lordship.
No right cause of action.
It's on time. Government will take its own time.
We may say only
Madam,
that if they evict you, they shall
Follow the.
follow the procedure established by law.
I have LOTs, madam. We are LOT.
Where is the allotment? Where? Where?
Oh,
Huh?
No,
I know it. I've seen it. It doesn't take much time.
madam, in that case, my lord, coordinate bench, my lord.
Coordinate bench is coordinate bench. I give you a very good idea
It is not
that
done,
when the
madam.
coordinate bench passes an order and this court does not follow it,
Madam,
then division
Your
bench is the
lordship,
right
it is
resource.
not in my favor, man. It is not in my favor, but it is lying, madam.
Not necessary. That also you don't require. I will protect you to that extent that if they want to evict you, they shall do so only by following the procedure established by law. That's all. You can get
Oh,
moved.
my lord, then what will happen? Your lordship will see the notification. This 13th.
Yes. What is it?
This notification says, my lord, the landless person can apply.
So,
Apply for settlement.
so,
I have applied for settlement, ma'am.
so,
But without considering our application, if they evict us, my lord, would it be proper?
where is your statement that they are coming for eviction?
Yes, my lord.
Where?
Para 8, ma'am. The land policy 2019, my lord, I am entitled settlement.
So what?
No, your lordship will consider.
No, first and foremost, does filing an application gives you a right?
No right, man. No right, but. this-
There's no right. You can be thrown out by following the procedure established by law by issuance of notice. Unless you challenge Rule 18. Challenge it in the division bench.
In that case, my lord, division bench judgment, my lord.
Ah,
And your lordship was one of the
ah.
last one. Your lordship can pass that order, the without eviction will not be. Because we. applied-
Without?
Without notice, man. Eviction notice.
That is what I am saying. That is the order I am passing. Then I was giving you a more opportunity of They're saying the procedure established by law means 18. I am not only saying that do it by the 18. Procedure established may also include filing a case under the Assam Land Grabbing Act. The moment I issue without notice, they will immediately give the notice and throw you out. Do you know the problem? I know it. So I can therefore mention that without following the procedure established by law and laid down by by this court in the case of Salakuddin. Done? Tell it. Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner. Mr. B.J. Talukdar, the learned senior counsel assisted by so and so appears on behalf of the respondent number 2, 3 and 2, 3 and 4. You are for respondent number 1. Taking into account the grievance of the petitioner, the instant with petition is taken up for disposal at the motion stage itself. The case of the petitioner here is that the predecessor and interest of the petitioners have been in continuous possession of the land presently under the occupation of the petitioner since the last 50 years. The 5 petitioners herein have filed individual applications seeking allotment. It is noticed that one application was filed in the year 1/4/2023. The second on 10/1/2025. But the rest of the 3 is in the month of December 2025. It is the case of the petitioner that though these applications are pending on 3/1/2026, the petitioners have been threatened that they would be evicted, apprehending that the petitioners would be evicted without following the due process. The instant writ petition has been filed. It is no longer res intriga that if the land in question is a government land, the government can evict those petitioners by following the due procedure established by law. These aspects have been duly dealt with by the learned division bench of this court in the case of Muhammad Salakuddin versus State of Assam and others reported in so and so. Taking into account the above, this court observes that if the petitioners are to be evicted, the respondents herein shall follow the procedure established by law, as well as the mandate as laid down by the learned division bench of this court in Salakuddin Supra.
Item number 9, similar.
Absolutely no. These other, you don't ask for my permission, ask the permission of the other councils. Turn around, ask the permission from the other council. Would they permit you? Because they are waiting for their turn. Yes. Item?
Same.
Same. This is 9 or 19.
9.
9 same. It is khali it file over there. On keta petitioner ase.
7.
7. How many persons have filed applications? All filed in the month of December. Oh, you have filed a cartel. All filed in the month of December. Huh? Difference all here applications have been filed in the month of December 2025.
67 supplementary. 69 supplementary.
Same.
Same.
You got hold of so many councils out there. Hey, are you kiba ta ase? File. Yes, what is this maze?
Good morning, Lordship. My name is Santosh Singh.
Hmm.
And I'm the petitioner in person. This writ petition under Article 226 arises from continued police atrocities and inactions coupled with 46 steps. And I am seeking, despite a lot of written complaints and section 107 CRPC, seeking preventive protection. The police have neither acted fairly nor protected my life and liberty.
Who are you?
My name is Santosh Singh and I'm the petitioner in person.
That I know. But I'm asking, who are you? Is there an FIR registered against you?
Pardon, sir.
Is there an FIR registered against you?
There are.
Who has filed?
It was filed by a lot of different people, sir. I
Ah.
would like to draw the attention of honorable court to para number 22. And in para number 22, the case has been mentioned. The petitioner directly state that the petitioner has been falsely implicated in Hojai police station case number 51722021 under section 294-506 IPC and number 103-2025, which is the recent arrest.
Were you arrested?
Yeah, sir, in 517/2021, I was arrested.
5-1?
517/2021, I was arrested by police and
When?
at night time, and I was
Obviously, night or day, I'm not on that. But when were you arrested? On which date? Huh?
See the date. The case number has been mentioned. It is in the year of 2021.
You have to give the date. Huh? You are asking for compensation. Are you not asking for compensation that you have been illegally detained? Are you not asking for?
No.
Now, my question is, as you are a petitioner in person, let me make it very clear to you. From what you have seen, from the materials as I could see, there's a case being 517/2021 and Hosai Police Station case number 103/2025 have been initiated under section 107 of the CRPC, isn't it? Are you sure? Because 107, if I'm not wrong, is a non-police case, isn't it? 107 proceedings is a non-police case.
Not, that's why.
So
my
it
lord,
is, it is more like a civil case,
Civil
which then later on becomes a 144, 145 proceedings. So it is only 107. It can't be under 107 you can be arrested. It is not, can't be permitted.
The lordship.
Huh.
Para number 22 have mentioned that under section 294/506 IPC.
Under?
Whereas in the-
Okay.
whereas
So
in-
you are being done under, Hosai is under section 294 and 506. What is this 294? No, you're going to look CRPC, IPC. CRPC going to look IPC. Yes, 294. Yeah. Obscene acts and songs. And 506. You can't be arrested under 294.
Your lordship, it's a willful act of police. It is going on since 2017. And I don't have so much amount to hire a private lawyer, so I was tolerating their atrocities. But finally, I have decided that I should approach the honorable court. And this arrest of 517/2021 is totally violation of Supreme Court guidelines DK Basuhan and Anish Kumar. So I was arrested and kept in police lockup for whole night. Whereas in one more case has been registered, 103/2025. This particular case is
103.
103, yeah. It's a counter blast, means
A BNS
it's a
concern?
revenge FIR.
Now you are out.
Yeah,
Now what do you want? What should this court? Grant protection of their petitioner in connection with so and so. These are bailable offense.
no non-bailable offense.
Mister, are these not bailable offense?
Lordship, I have to.
Page 22, paragraph 22. Where is the FIRs?
FIR, my lord, he did not annex, lord.
You have not enclosed the FIR.
The nominator sitting there.
Have you annexed the?
Oh, there, page 39 is one.
E-complaint is.
This is what? This is your complaint.
Yes. Yes.
Okay, these are your complaints. Where is the FIR?
The FIR has not been attached with it.
Oh, Mr. Santosh Singh. No, wait. You don't want to take the help of the council is okay. But the question is, I think you need to take some help. Let this court help you out. I understand your grievance. You have been arrested in a case which is otherwise bailable. If these sections are looked into, it is otherwise bailable sections out there, the question of arrest doesn't arise. So therefore, you are trying to make out a case of a constitutional tort. DK Basu is a case of constitutional tort, illegal arrest and all. You do one thing. Let us have this matter again on 20. In the meantime, you get those FIRs. So both the FIRs, there are two FIRs, and place it before the court by filing an affidavit. Okay?
Your Lordship,
Wait. Yes, Mr. A. Chakraborty. Come over. Young advocate. Help him out. I'll put your name as an amicus in this matter. Okay? We'll hear you. You took him free of cost. Okay? But you provide him the FIR of these two. Okay? He will help you out.
Lordship, can I present something more?
No. First, without the FIR, I can't look into it. I'm helping you out with a counsel free of cost. But then also.
Thank you.
Yes. The petitioner herein have sought for redressal of his grievances on account of on account of an allegation, on account of certain alleged harassment committed upon the petitioner, thereby resulting in a constitutional tort. It is the opinion of this court that the petitioner in person, in order to place his case, may require certain assistance. Considering the above, this court requested Mr. A. Chakraborty, the learned counsel, to assist the petitioner in the instant proceedings and appear as an amicus so appointed by this court. Mr. A. Chakraborty, the learned counsel, submitted that he would be willing to aid the petitioner in the instant proceedings and make necessary submissions. Accordingly, Mr. A. Chakraborty is appointed as the amicus curiae by the court and his name be indicated in the cause list. It is the opinion of this court that for the purpose of initiating any proceeding, the present proceedings, the FIRs in question has to be brought on record. The petitioner would take necessary steps for bringing on record the said FIRs by filing additional affidavits. List this matter again on 23rd of February 2026. We'll see it. Okay? He will help you out.
Thank you.
We'll talk to him. Yes. Yes, what is this?
The voters.
The petition representation of so and so filed by the petitioner at the earliest of the provisions within a stipulation. What petition is this? Where is PNRD? Yes, what is this petition? 25/9/2025.
My lord.
25/9/2025. Where is the petition? Mr. Counsel.
Representation is page number 25.
Okay, complaint against Salima Begi, who won the ward member of ward number so and so for a false affidavit and year. So,
In this figure 25, page number 28.
so
At the time of.
this is election, Panchayat election.
Yes,
Is there an election tribunal?
yes.
Why you are not there? You have to file an election petition. Is it so?
Yes.
Where is it? Panchayat Act. So you have no business. No, wait. If you are not the contesting candidate, what business you have? Why you are fighting all these things?
Particular area.
Huh?
And the voters of that particular.
Show me the election rules. Where is it? Mr. Dutta, which one will be the election rules?
My lord, the one
There will
20,
be an, huh?
in the act itself, my lord,
Yes, section
section 127.
10,
127 is the tribunal, my lord.
1, 1.
127.
127 is the tribunal and 129 there is a barrier.
Okay. 127.
And 129 there is a.
129B is the bar.
Notwithstanding anything contained in it, the validity of any law relating to delimitation, no election, any panchayat shall be called in question except by an election petition presented within from the date of so and so to Iman. Where's the bar? Where's the bar?
Right.
That is why I tell you.
Lordship, accordingly, pursuant to 127, your lordship, tribunals were created as follows. There is a. So far as jurisdiction is concerned, your lord, only the contesting candidate.
What is this document?
This is the ordinance, your lordship, creating the tribunals, your lordship.
Then you have to challenge this. This notification cannot be in terms with section 127, 29. Because you see, the same provision is applicable in respect to 329 also, 329 of the Constitution, as well as also section 81 of the Representation of People's Act. Therefore, you find many other persons also can challenge it. This, by way of this notification, you cannot be stopped.
They cannot be left.
Have you filed any application?
No. Yes, I filed a representation before the deputy commissioner.
No. Deputy Commissioner can't do anything. An election cannot be called in question by anybody else except by way of an election petition. Matter is very sacrosanct, clear, absolutely. This court cannot issue any direction to that effect. Now, for overcoming it, you have to challenge it by this. No, that will be Article 329, na?
Yes.
329 of the Constitution. It's same principle.
You have very less, your lordship, because of this.
Who are you? Why didn't you contest? I'm not going to entertain this type of
I preferred bit of power and to your lordship.
liberty given to challenge this, and then The law is very clear. You cannot challenge it except by way of an election petition. Now, the election petition has been stopped by way of a notification. You have to challenge that notification in order to overcome.
129B, my lord. 129B. Specific bar is there, my lord.
I can't. Leho, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S. Dotto appears on behalf of the respondent numbers.
My lord, I'm
1,
1, 3,
3,
5,
5,
6, and 7.
6. Over নাম সামনে দিব জুন নিপিয়া করছে। Taking into account the dispute which has been raised in the instant proceeding, this court takes up the matter with petition for disposal at the motion stage itself. The grievance of the petitioner herein is that the respondent number 8 had won the ward member of ward number 10 of number 1 Bokhorsal Nairgram Gaon Panchayat under number 4 Srimanto Kanisoil Basial Jila Porishad by submitting a false affidavit and fake SSLC pass certificate at the time of nomination of the Assam Panchayat elections in the year 2025. Admittedly, the petitioner is not the contesting candidate. The question therefore arises, and the petitioner submitted a representation on 25/9/2025 to the district commissioner Sri Bhumi, and the same having not been taken into consideration, being considered or disposed of, the petitioner has approached this court. This court finds it very pertinent to take note of that section 129 of the Assam Panchayat Act 1994, which bars interference by courts in electoral matters. The said section, being relevant, is reproduced hereunder. From a perusal of the above quoted section, and more particularly clause B of section 129 of the Act of 1994, it is clear that no election to any panchayat shall be called in question except by way of an election petition presented within 60 days from the date of declaration of the election results to the tribunal constituted under section 127. There is no doubt there are tribunals constituted by the state of Assam in that regard. Considering the above, in view of the bar contained in section 129 of the Act of 1994, this court is not in a position to issue a direction upon the District Commissioner Sri Bhumi to consider the representation of the petitioner. Accordingly, the instant petition stands dismissed. Hey, Deepjyoti Deka. Madam, I want trying to help you out. Because we are only concerned that State Public Commission information is not doing the needful. So have it out there, we'll take it up and finish it off. If we issue notice like this for another 4 weeks, because you see, the basic idea is to finish off within 30 days. So if the very purpose of the act becomes ineffective if I issue a notice like this.
My lord, in the cause list also only secondary education name has been shown, but my lord, public information commission has not shown here, my lord.
Huh?
Public information commission has not been shown in the cause list.
That is what, yeah. So Deepjyoti Deka, standing counsel of BA. The registry shall also show the name of Mr. Deepjyoti Deka in the standing counsel of the Assam State Public Information Commission in the cause list.
Item 15.
Yes, what is this?
Additional companies engaged in real estate business. You know, they completed the project in the year 2018. And you know, they handed over 123 independent dealers the year 2019 itself. Now, you know, in the year 2023, 5 purchasers, you know, they went to, you know, National Green Tribunal. And, you know, they made some complaints, and the basis of that, the National Green Tribunal passed an order
Where's your impugn order?
that, Lord, there is, I'll take your lordships, on the
First,
basis of
take me to the impugn order.
Yes. In order is, your lordship will find it page 66.
Huh?
Page 66. Sixty-one. That's dated 15/2/2025.
61.
61. Letter dated 15/2. Two Messrs so and so. Compliance of order dated 12/9/2024, passed by the Honorable NGT Eastern Coast, Kolkata, lawyer number so and so. In compliance of the above order passed by the Honorable NGT Eastern Brothers, Kolkata, the committee has submitted its report to the office of SEER. SEER is below to the State Environmental Impact Assessment Authority. On 29/1/2025, and placed the same in 13th meeting of SEER. After perusal of the observation and recommendations of the committee, due discussion and deliberation, the SEER unanimously decided to send a copy of the report to the project properly. We are therefore requested to comply with the observation and recommendation of the committee suggested. Now, your lordship may kindly see the report about it, which your lordship will find at page 63.
Page?
63, 63.
Now, what is your grievance for that?
Now, your lordship, I'll just take your lordship to the observation part, the relevant part. Well, your lordship may kindly see at page 68. The somewhat after PWD drain, the area surrounding, well, from there I read. The area surrounding the area smart living campus has undergone significant terrain modifications due to extensive construction activities in adjacent areas, like upgradation of road waters. The existing drainage system inside the area smart living campus requires comprehensive redesign and major rehabilitation work. This would necessitate advanced terrain mapping and hydrological assessment. Now, here, my lord, it is admitted that it is not our fault. Because the adjacent area is the PWD road. So the road was, my lord, after the construction, it is, the height of that road has gone up. Therefore, my lord, when there is a rain, my lord, the rain water gets submerged in the open area. And there is apart from that, there are many other complaints. Then your lordship kindly see at page 69, last but one para. Committee does not have required time, budget and technical resources to do this entire study itself. And therefore suggests SEER orders the respondent number 1 as per the NGT order to institute entire study as mentioned above by engaging with competent public sector organizations. My lord, task of making a further inquiry has been given to me. Now, whether, my lord, I can do it on the basis of the order passed by the honorable end. Then, my lord, I will take your lordship to page 163.
Now, they say that they have done it in terms with the Green Tribunal's order.
Very right, my lord. What I want at this stage, my lord, your lordship kindly see at page 163. I just wanted some guidance from them. Your lordship kindly see at page 163 and after that.
Yes.
Lord, your lordship, in reference to the direction issued by order dated 15/2025, received by us on so would like to bring the following points to your kind attention. We have submitted documentary evidence establishing that as per the provisions of the Assam Apartment Construction Act 2006 and the Assam Apartment Construction Act, the villas constructed on the campus are no longer our property after the sale. Consequently, initiating any action as per your suggestion should amount to trespassing which is legally untenable. Then the villas including phase 1, phase 2 and the clubhouse were constructed following the NOC issued by GMD, then Gau Panchayat and NG and accordingly we applied for and obtained the required occupancy certificate which were duly submission for your reference. Unauthorized construction by owners. Certain owners have undertaken unauthorized construction with their OC being categorized as part of C. Evidence of the same have already been submitted to you by our submission dated so and so. Any further deviations as suggested cannot be permitted under any regulatory framework since these modifications or alterations were not part of the sanction plan. Then environment clearance. The circular dated so and so specifies that EC, that is the environment certificate for projects under schedule so and so is issued in accordance with the sanction plan. The MOEF notification dated so and so has further clarified that minor deviations in the conceptual plan do not require an amendment to the EC. And Waterloo, your own report highlights the substantial ongoing construction around the campus and the construction of.
Why you not going to the Green Tribunal?
Well, the proceeding is pending there.
Go there, file an IA.
Lordship, in
Well,
fact,
with all respect, London is not a party here.
It's okay, I'm not on that. I'm not even hearing him. I'm asking you.
But-
Why you're not going to the Green Tribunal?
Green Tribunal already is pending there.
So there, file an IA, ask that this is these are the directions passed on 15/2/2025. We have difficulties in complying with this, taking into account that we don't control the entire thing now. Only a
Yeah.
part of it has been, most of the part have already been sold off. How do we take care of all these things? Now, for that, you have submitted an application on 27/3/2025, which have not been considered. Seek a clarification from the Green Tribunal. It is because of your order this has happened. So therefore, now we are in this position. Kindly help us. David, the fear is, if they go there, they may pass an order immediately rejecting any other matter ends there.
Can you lordship should direction?
Why should I?
An observation.
I can only dismiss it, taking into account that as the matter is pending in the Green Tribunal, they can go there, not here.
yes. In fact, Lordship,
Well,
there are two matters. They have filed a review application, which is pending, and it is fixed next month, Your Lordship. I have the order. And we have filed an execution application where the entire matter is dealt in the executive application. They have appeared in that EA. and
They have filed an IA that has been now, that IA has been, they have taken the liberty to file a review.
They filed the review, Your Lordship. Now that is fixed on March. And the execution application we have filed, Your Lordship, where they have participated, that is fixed on 16, Your Lordship. And they have submitted their rejoinder also in that application. They can approach the NGT, they can file a MA, or they can submit the grievance
So
before.
when a matter is pending before NGT, why should we look into it? And this is pertaining to certain directions of the NGT which was passed. Orders were passed by the SIEE, and thereupon the recommendations were given and they were asked to comply. Then they submitted an application for how to comply, seeking suggestions. If they have not done it, go before the NGT.
Yes.
NGT will help you out.
Yes, Your Lordship. I'm obliged, Your
What
Lordship.
they have done, they have filed an application for the engine, filing an IA application that we haven't complied the order. Because then subsequent date, my lord, they have withdrawn.
Lordship, that is not the correct,
This is the-
that is not
going on, my lord.
that is not the correct picture, Your Lordship.
Whatever may be, you go and approach the NGT. Why should we look into it?
My lord, in the meantime, if the lordships gives us some protection.
No protection. I have no jurisdiction.
Hmm.
So far, IA application to clarify all the matters, my lord, very right, we can file an application over there. But
Matter over. That is the only thing.
Yes.
Go there. I'm not going to touch these things. We have better things to do, look into panchayat matters. Well, we dismiss it. Without prejudice for you to approach the NGT.
The proper page 61 is concerned.
Huh?
Page 61, that is the, which order I have changed to the lordship.
Ah. So,
If, for the time being, my lord, this order may be kept in abeyance.
read your, Mr. Datta, kindly start reading your synopsis, the first letter, first paragraph of your synopsis.
Synopsis.
Read it. Aloud. For others to hear also. You categorically say that this is the order which is there.
Yes.
You are trying to implement, but you are not in a position to
Right.
implement, for which you are asking. Meaning thereby you have all intentions to implement. When you have acted on that, and then you are facing difficulties, so we should see that.
In the sense, my lord, there are the, say, like NOCs and all that by the state authorities. Now, if we want to change it, my lord, we shall be in a very hopeless position in the sense, my lord, the authority will ask, how you are doing? With the statutory authority, they will ask, we have given a NOC, you should be basis of these documents. Now, on the basis of the order passed by the respondent, that is the state environment.
See, the NGT has passed an order. The effect of that has been given by the SIE, whereby leave has been, there's a specific direction that these aspects will be looked into by the SIE. SIE have looked into not properly or rightly or wrongly. This is for you to complain it before the NGT. And if you agree by the NGT order, then the Supreme Court is there, not this court. So we dismiss. So therefore we dismiss on that ground.
We needed some guidance, how.
I'm not here to give guidance on that. I can only dismiss this. Let us dismiss.
Well, they will express in page 163, what is our, the representation we have filed. In the light of that only.
I've looked into it.
Till the disposal of that, they did not do anything, they said right over there.
No, Mr. Datta, you also know, I also know. When you start constructing, you must have taken the land either on your own land you have constructed there, or you have taken it from somebody on development agreement. When you are constructing and selling a particular plot of land to somebody or some villa to somebody, you are required to comply as per law. The NGT categorically holds that you have violated and thereby directs the SIE to look into it, what remedial actions can be taken. SIE gives a finding out there that these are the remedial actions which were taken. You say that it is not possible for you, taking into account that I have already sold it. But the sale which has been made by you, violating the provisions. You are to face the consequence. If you are not, there will be penalty after penalty. You go to NGT, only advice I can give, go to NGT and then move the Supreme Court. Look here, the matter is pending as regards the environmental clearance not taken earlier. Subsequently, the matter is pending.
Terms of, page 163, is told that our grievances we have violated.
Mr. Doctor, that would be this court exercising a jurisdiction which this court would not touch it, in view of the NGT being in session of the matter.
I understand.
So we dismiss it. Dispose of what? Now dismiss it without prejudice for you to approach the NGT. A rose is a rose in whatever color it is. Is a dismissal is a dismissal. Now, heard Mr. S. Dutta, the learned senior counsel, assisted by Mr. A. Biswas, the learned counsel, appearing on behalf of the petitioner. Mr. SIU.
I am appearing for CIS.
Mr. So-and-so appearing on behalf of the respondent number 1, GMDA. Mr. P. Naik, is he around in the four corners? Okay. Mr. P. Naik appears on behalf of the respondent number 2. Government? No government counsel. Mr. J. Hendrik appears on behalf of the respondent number 3. Assam's Real Estate Regulatory Authority. Who is this? Okay. Taking into account the order which this court proposes to pass, this court dispenses with the notice upon the performer respondent number 4 and 5. The grievance of the petitioner herein is that the petitioner had submitted a representation on 27/3/2025 pursuant to the directions issued by the State Environment Impact Assessment Authority, bracket SEIAA, on 15/2/2025 to duly comply with the said recommendations. And the said representation dated 27/3/2025 have not yet been considered with. It is under such circumstances, the petitioner being in difficulties, have approached this court by filing the present writ petition. This court duly takes note of that on the basis of certain complaints being made by one Ganesh Das and others, a proceedings was initiated before the National Green Tribunal Eastern Zone Bench, Kolkata, which was registered as original application number 92/2023/EZ. By an order dated 12/9/2024, certain directions were issued না 12/9/2000 নহয় তার আগত যাও। The order dated
So page 138, Your Lordship, the directions.
no. Prior to that, these directions are there, na? This is the direction, na? Page 104.
138 is the direction.
No,
Para
104.
55, Your Lordship.
Huh?
138.
138.
Yes, Your Lordship. Para 55, it continues,
Are certain directions.
goes 138, 139 up to 140.
Whereby the SEIAA along with the Assam State Public
Pollution Control Board.
Pollution Control Board to work out the cost incurred in expansion of the project and determine the environment compensation. Further, the SEIAA was also directed to carry out the remedial measures on damage assessment Full stop. There were further directions have been made, thereby directing the SEIAA to take action against the petitioner for violation of the EC condition by complying with the principles of natural justice. Full stop. In pursuance thereto, the SEIAA took up the matter in the meeting and took up the matter, and by the deliberation being carried out and submitted a report on 29/1/2025, thereby giving certain directions, giving certain recommendations. In pursuance to thereto, on 15/2/2025, the member secretary of SEIAA had directed the petitioner the member secretary informed the petitioner that the SEIAA unanimously decided to send a copy of the report to the project proponent, and the petitioner was further directed to comply the observations and recommendations of the committee as suggested in the said report. The petitioner thereupon submitted an application before the chairman, SEIAA, on 27/3/2025, stating the difficulties faced by the petitioner to comply with the directions issued by the order dated 15/2/2025, which the petitioner received on 4/3/2025. This application, however, have not been considered, and under such circumstances, the petitioner has approached this court seeking interference with the communication dated 15/2/2025 and other consequential directions. This court have heard the learned counsels and is of the opinion that the matter in question emanates from certain directions passed by the National Green Tribunal in original application number Iman from the order dated so-and-so in original application number so-and-so. It is further seen that on the basis of such directions, the SEIAA have taken certain actions, have made certain recommendations. The communication dated 27/3/2025 issued to the chairman SEIAA also shows that the petitioner is, though interested in complying with the directions passed in the order dated 15/2/2025, but the petitioner is not, in view of certain difficulties stated therein, the petitioner is not in a position to comply. It is the opinion of this court that these aspects ought to have been agitated by the petitioner before the National Greens Tribunal. During the course of the hearing, Mr. S. Barua, the learned counsel who appears on behalf of the respondent number 1 submits that the petitioner have also filed a review application before the National Green Tribunal in respect to the said issue. Puts- Taking into account the above, it is the opinion of this court that entertaining the instant writ petition would be in conflict with the National Green Tribunals Act 2010 and also would not be in the interest of justice, taking into account that the National Green Tribunal Eastern Zone is also taking up the matter on a review application so filed by the petitioner. Accordingly, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed without prejudice to the petitioner to seek remedies before the National Green Tribunal if so advised. Yes, what is this? Same order. Mr. Sutia, I have changed that order to certain extent. You have got it?
Well, that has not been uploaded.
Well, I think you'll get it. I've changed the order to that extent that instead of 15 days, I've given 30 days. But to submit a representation, what has happened in that order, they have seen the particulars. Particulars is very difficult. You have to submit a representation along with the particulars. And after submission of that, within 30 days, they will consider and thereupon pass a speaking order. Till the speaking order is not passed, they shall not be evicted.
Speaking order in each application, each representation.
So they will file, everybody will file a respective application against that speaking order.
Because you want to file the applications, they would get discounted.
So same type, huh? Because 15 days is too short a time.
18.
Same.
Except 19.
No.
Cancellation of this GST registration.
Why?
Not submitted.
Where is the GST Council?
Focus notice. Yes, dispute of matter, item number 6.
So what is your case? In 2000, did you submit your reply? Why didn't you submit your reply?
Don't receive the focus notice.
But it will be given in the portal. Anyways, we passed that same order today. Item number 6. But there the difference is there was no reply submitted. There was a reply submitted, here no reply. So no reply submitted will come within that ambit, na? So okay, I've got it.
Think 38 tera.
So this will be the same type order. Disposed. Where is the this one? This is which department? The state of who has done that? The state of Assam. Where is Mr. B. Chaudhary? This is to be by B. Chaudhary only. No B. Chaudhary. Where is he? Chaudhary is not here. Isn't it? I will dispose it of. Just bring him. Dispose of করিম তাহলে ফোন দেখালে হবো। What is this?
Settlement between the parties. So we are not placing the case in. There was dispute between two factions, running lower court. Middle faction was not allowing the petitioner society to. Subsequently, as on the judgment, the dispute has been solved.
Any instructions?
Lordship, it was amicably said today.
Amicably settled.
Settled.
You want to withdraw? Mr. So-and-so submits that the matter have been amicably resolved and as such the petitioner would not like to press the instant writ petition. Taking into account above, the instant writ petition therefore stands closed. Yes.
Here in this case, and 9 schemes were prepared and selected from the only 4 wards.
Huh?
Petitioners, the 6 ward members, they have not provided any scheme to the petitioners or. And in addition, in violation of the mandate of the Gauhati, this is exercise.
What has happened? Proposed list of schemes selected in respect of the 4 wards and declared the same. Why?
Or only because Gauhati consists of 10 ward members. This Gauhati consists of 10 members. At the time of selection of president and vice president, petitioners are the one side and other 4 members are the other side. They from the Gauhati. Since then, they are defending us. And in this regard, petitioners approach this honorable court. Challenging the selection and selection of the president and Gauhati. This honorable court disposed of the matter directed the commissioner to consider the representation as per section 11 of the Panchayat Act.
Then?
This is pending before the deputy commissioner. And in this case, they selected the schemes depriving the petitioner.
Now what has happened?
The scheme is 50 years, but money is not released till today.
What?
Scheme is prepared, my lord, page 37.
37.
Yes. Till till 9 number prepared against the ward number 1, 2, 5, and 8.
Then?
Then my lord, till today, the respondent authority has not released the pension amount.
Who?
For completion of the work.
Who are you?
We are the ward members of the Gauhati, 6 ward members.
You need the money for whom?
Against the scheme. Against the scheme.
Did you do any work?
No, my lord, we are not selected. No scheme provided us, my lord.
No. You see, construction of community hall near Abu Qasim's house, Maktab Ali School, so and so. Now this amount is rupees 3 lakhs.
Yes.
Now did you construct?
This is the scheme implemented by the Gauhati.
You are not the.
So my question therefore is, if you have not constructed,
These days not constructed, work not started.
so who are you?
We are the ward members.
So ward members, what is the business out here for them?
Ward members, my lord, as per guideline, my lord, it will fair shall be distributed among the whole world.
All the words.
Yes, my lord.
So
That
your
work
case
has not been
is,
done.
so your case therefore is that this selection which are the schemes which were selected did not provide benefits to those words for whom you appear.
Yes. Yes.
Isn't it, Mr. Dutta?
Yes, my lord.
That is his case.
Yes.
Yeah?
And also his allegation is without holding the Gao Sabha, there is a proof, my lord. In similar case, Lordship had issued notice morning.
Morning, yeah.
Yes.
Issue notice making it returnable on, when did I fix that matter? Item 1?
And,
On 9th of, is it item 1,
yes,
na?
item 1.
On 9th of March 2026. So and so, S. Dutta appears for 1, 2, 3, 5, 6,
And 8.
and 8.
I'm for 4.
And so for 4. Extra copies of the requisition be served upon the councils. As regards the respondent number 7, steps be taken by way of speed post by tomorrow. In addition to that, liberty given to take service, effect service upon the respondent number 7 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner should ensure that the service upon the respondent number 7 is completed on or before 19th of February 2026. The grievance of the petitioners herein are members of ward number of various words.
Call number 9, 4, 3, 10.
Of various words under the Daipam Gaon Panchayat. The grievance of the petitioner herein is that the president and the secretary of the Daipam Gaon Panchayat have unilaterally chosen the schemes under the 15th Finance Commission in respect to the words wherein, in respect to those words wherein they have persons, wherein the ward members are of their liking. However, the respondent, the respondent number 7 and 8 have not provided any schemes in the wards wherein the petitioner are the ward members. It is under such circumstances the petitioner has approached this court. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 27th of, on 2nd of March 2026 as to why no schemes have been, as to whether schemes have been provided in the wards belonging to the petitioner, wherein the petitioners are the ward members, in respect to the wards wherein the petitioners herein are the ward members, and if not, the reason therefore.
Item 69.
Last.
But very unequal situation was really
Yes.
wait a minute, absolute owner and possessor of plot of land, having our dwelling houses situated in Palasbari. And we are living in this portion of land since last 50 years. This is our ancestral property. Adjacent to our land, there is a Gubar. That's the animal corridor shown in the map. And this Gubar is the differential line of Kamrup Metro and Kamrup Rural. Our person falls in Kamrup Metro. And after this animal corridor, this is Kamrup Rural. This contiguous dam, just in that side of the Gubar animal corridor, it belongs to the private respondent. And they always threatened us to occupy our land, said that their lands are inside my campus. So we filed a petition before the circle officer to demarcate this land. They always come and threaten us and creates chaos. So we applied for a demarcation. And the circle officer issued a notice calling all the parties fixing 8 January 2020. On 6th of January, a whole huge team came into my place, along with police and CRPF personnel, circle officers of Kolaswari Revenue Circle and Ajara Revenue Circle, along with the officials from the Land Records Department, with police staff, entered into my premises and dispossessed us.
Dispossessed
Dispossessed.
entire land.
Not this, the vacant portion. The building is there. Top of everything else, what it did, they installed barricades in front of our main gate, boundary gate. So no entrance, no egress. And we immediately find FIR, no action, because this, put the police involved. They cut our electricity. See the level of degradation. They cut our electricity from our dwelling house. Then we filed a representation before the DC, no, nothing, CDC, nothing. Then we approached the Honorable Chief Minister. Honorable Chief Minister interfered with. Then the electricity was restored. Then, my Lord, basically, on 6th of February, they issued a notice to us for hearing. Fixing today.
Then?
Fixing yesterday, my Lord. Fixing, it was fixed on yesterday for hearing at 10 AM, but by telephonic instruction, we are asked not to come, it is adjourned. For not, without giving any positive. This is how we are before your Lordship. But at this stage, what I sincerely pray, at least remove this barricades from our gates, so that people can come and go inside. And all the goons are taking camp there, uttering filthy languages on us, on our females, on the family members of us. We find FIRs, no action, nothing. We have heard it happening in some other states, but not in a sense.
Okay, we'll take in this matter in the second half. In the meantime, you obtain instruction. What happened on 10-2?
10-2, they said this was adjourned.
No, hearing was without assigning any reason, it was adjourned.
Then give a copy to him.
Fine.
We'll take it up in the second half, around after 3, because I have certain matters. After that, I'll take it up.
Fine.
We'll take it up and we'll look into it. What is it?
Only thing, my Lord, that if I can say one thing, I'm sorry. My Lord, even if there is a border boundary dispute, maybe I just presuming it for a moment. Is it a way to dispossess someone without a competent court's order, without following due process of law? The police will go with some hooligans and dispose of all the parties there. So they are living there in ancestral property last more than 50 years. How can the government agency be a party to this hooliganism? Government agencies has to be custodian of law, my Lord, deputy commissioner, circle officers, police personnel, land records department, what not? And the Honorable Chief Minister interferes, then this hearing notice comes.
Let's see what happens. We'll take it up.
Man,
Mr. B. Chaudhary, that matter registration will pass the same order which I have passed
Yeah.
in the morning. They'll submit the returns of everything, and then thereupon they'll have to pay all leave fees and everything.
Yes.
And then all the things will happen.
my Lord,
Because
take a-
they have to first submit the returns for the purpose of regularizing. Then only they can.
Then only they can.
So therefore, the period of limitation also I have taken care of in my order, whereby the period of limitation till for the year 2025-26 will be as per section 44. But as regards the others, it will be as per on the date of this order, because otherwise you lose out on section 7310.
73 goes up.
But this will be under the State Act. Assam State General. The provisions are same.
Same,
7310, you know.
my Lord, 3 p.m.
3 or 4 p.m. I'll take it up.
Maybe
Don't
not.
worry.
I'll be here from 3. No issue.
We'll first look into that.
My Lord.
It will dispose of police. Item it to reach or the issue. Huh? Okay.
My Lord.
I apologize for not being there in person. I'm a little under the weather since yesterday. So I'm on VC today. But I mean, my learned friend, of course, it's his petition, but if Lordship wants me to assist the court at the beginning with regard to the directions in Lordship's order, I could give a quick overview of that. And then, of course, we are in your hands. I'll have some things to argue thereafter. Lordship, we had come on the 29th, and Lordship's directions are primarily in para 7 and 8. Lordship, there were two aspects what Lordship wanted us to have information and update Lordship. One was with regard to the procedure of the OMC, and the second is on the action taken report, Lordship. The procedure was linked to the issue of the alleged non-compliance of section 8B and 8C.
Mr. Kohli,
Lordship.
as I could see, if you read section 3(4), it says that the commission's report has to be submitted
With an ATR.
within a period of 6 months, but then also the Supreme Court have held it not to be AR.
Exactly, Lordship.
Yes, I've
Well,
seen to that effect.
I'm grateful because Lordship.
To that,
Lordship.
it's not the High Court, it is even the Supreme Court have looked into it. And in fact, the Supreme Court have also said that there should not be much delay in placing these materials before the Legislative Assembly. But the fact remains that the report can be looked into, although it is recommendatory in nature, can be looked into for the initiation of disciplinary proceedings. There's no quarrel with that proposition.
Of course, Lordship.
Now, the action taken report, along with the action taken report with the word use, that an action taken report means some action has to be taken on the basis of the said report, meaning thereby that not only the report, along with that, certain actions are to be taken. Now, if the actions have been taken, maybe the action taken report was not submitted before the Legislative Assembly, the resultant effect is that the legislature is not in a position to debate on the said issue, on the report. So therefore, that may be another aspect of the matter. But on the basis of the report, how do you take an action on that report unless, or submit an action taken report unless and until you bring into motion something to be done on the basis of that report? This fact is okay. There's no quarrel with that. But the problem is, as regards 8B and 8C, the only thing which requires to be looked into is, if 8B says that a notice has to be given in respect to this aspect, then whether a notice only stating that you are to show cause as to what is required to be done as regards this allegation, would it suffice? Or you are to also mention other rights which is involved therein. That is 8B. And because there is a consequential right given under 8C of a right of examination, cross-examination. And there is also no quarrel with the proposition. It is settled that a person concerned, he has to be intimated as to what further course of action has been taken. And the evidence is also, if evidence is against him, the evidence has to be also taken.
Yes, Lordship.
In his presence.
So may I, Lordship, just have 5 minutes, no more, and I will assist Lordship on all these points. So I'm grateful, Lordship, that Lordship has already studied and seen that section 3 and subsection 4 is directory, not mandatory. In fact, Lordship, we have also seen it. There are judgments to the effect, affirmed right up to the Supreme Court, full bench DBs of the High Court, which say that where the demand was, place the report before the Assembly. I mean, we are one step ahead. The report has been placed. The action taken report has still not been placed. That is factual, Lordship. But the action report will be placed. It is not as if it's not going to be placed because work is happening. So that was one leg of the argument. Let's pause it for a minute, Lordship. The
Now,
second,
in fact, without the action taken report, there cannot be a legislative debate. That is the only thing.
but yes, Lordship, and that is a separate issue as to, so therefore, Lordship, for a
Which has
moment.
nothing to do here.
Right. So, Lordship, I'll in fact assist Lordship even on that point.
So therefore, Mr. Kohli, let us go to 8B.
I'm coming. Just one sentence, Lordship. In fact, in one particular case where the commission report was not even placed, the Honorable Court noted that this government is already taking action. There is no requirement to place the report too. There is one judgment even to that effect. So the issue is the report is only
No,
for the.
let us not go digress to that issue
We will
there.
leave that, Lordship. Now,
let us come to section 8B.
Now let me assist Lordship with 3-4 things on 8B. So, Lordship, there is 8B, there is 8C. There
We'll
is
look into 8B and 8C and take into account the judgment in Vajpayee's case.
LK Advani.
There's also some
And
Vajpayee.
Kiran Bedi. There's no quarrel with that proposition.
Kiran Bedi is there, then another.
LK Advani.
Not this, our Prime Minister Vajpayee, there is another one, BAJ. Yeah.
Lordship, I'm sorry, but I think that has skipped our attention. I don't know if my learned friend is relying on that, but we have, of course, seen the rest of the law. We've got that compilation. And we'll certainly assist Lordship with that. May I just, Lordship, come on 8B, 8C?
Huh?
8B, 8C, if I may.
Yes, 8B.
Just for a moment, Lordship. First, I must point out, Lordship, because Lordship had asked for the OMC report to be placed and its annexures. The factual position is...
I have not asked. Mr. Kohli, I have not asked for the report. Court has asked earlier. I say if you don't produce it, there will be a presumption to the effect that he has
So,
not
Lordship,
been.
I shall
But I would not ask. It is it is you who is relying on that report.
The compliance required in terms of submission of the
This
report.
court cannot presume when there is an allegation being made that they have not complied with section 8B and 8C, and you say that it has been duly complied with,
of course,
or it is whatever notice has been issued, that is enough, and there is no further action required to be taken, then it is you who have to show me on the basis of the materials which is available on the basis of the report being made that this was done.
Now,
You don't
if
do
Lordship
it,
would bear with me on the
law will
report and the
go
material,
before.
I will
Okay,
assist
let's come to
Lordship.
8B.
So, Lordship, would you like me to read the section for a minute, Lordship?
Yes, yes.
So, Lordship, this is the procedure. 8B, persons likely to be prejudicially affected by to be heard. If at any stage of inquiry, the Commission A considers it necessary to inquire into the conduct of any person, or B is of the opinion that the reputation of any person is likely to be prejudicially affected by the inquiry, the Commission shall give to the person a reasonable opportunity of being heard in the inquiry and to produce evidence in his defense, provided that nothing in this section shall apply where the credit of a witness is being impeached. Lordship, now 8B is separate to the import of 8C. Let's read 8C for a moment. Let's also read 8C for a moment, Lordship.
Oh, yes, just one minute.
Of course, Lordship.
Where is that notice issued by the
92, Lordship, in Priyanka Deka. We will rely a lot on Priyanka Deka as the lead matter. So if Lordship would be pleased to come to page 92.
But the order at page 91.
No. Where is the notice issued? Huh?
92, Lordship.
90.
90 to 95.
No, I am taking up Acharya Jibon Buru.
Would Lordship take up Priyanka Deka? Eventually, Lordship, I'll request Lordship to take that file. It's 3 pages, Lordship.
Okay. So in the notice which was issued,
Lordship,
there was no mention that you can produce evidence.
so Lordship is reading. I would, Lordship, then request Lordship to also note the reply.
Yeah.
There are 2 parts. Replies at 97. So, Lordship, the reasonable opportunity of being heard and to produce. Now, reply would become relevant. Please come to the reply. And I must point out before we get deeper in this, Lordship, everyone inspected, some even sent counsels. Now, 39 notices were sent in the first instance, 39 replied. 39 was sent the second instance, 11 replied. Now, Lordship, 8C, 1 minute, Lordship, just one sentence. 8C, the right of cross-examination, one issue will come if the entire allegation is based on documentary evidence. And the documents are there, then the opportunity is to be given, and they seek, always given, to refute those allegations. Now, Lordship, the point is, if everyone has come and inspected also, chosen not to refute, then it is settled law that in that case, they cannot cry that there is a non-compliance of 8B. So I will show judgments later. Second, each one will have to be seen on a case-to-case basis because there are 300 annexures to the report, which, Lordship, we have not been able to place so far because it's voluminous in trunks. There, we have filed the report. It's been done. The annexures pertain to case by case, each person. Today in the court, my learned colleague is carrying at least Priyanka Deka and at least Acharjo, the 2 of them, which Lordship has sort of treated as a lead matter. So for you to have a look at, Lordship, what is the nature of the documentary evidence that was against them?
Understand, Mr. Kohli, are we to understand that these FSL reports initially formed the prima facie opinion that there is a requirement of issuance of notice under 8B. So there is a subjective satisfaction to the fact that the commission thought that A or B of section 8B is duly satisfied. There's a subjective, the moment the notice is issued. Are we to believe, because there you are mentioning, the commission is mentioning that it is only in respect to, there is a prima facie opinion on the basis of these FSL reports. Are you saying that these FSL reports, when tendered into evidence, means without a person? There was no person who adduced evidence in that regard.
Lordship, the argument there then would be the commission is not a court. The commission is only a fact finding. And that is how it is. It's settled law. The commission being a fact finding is to assist the mind of the government. Now, second, the government is not the commission, Lordship. In fairness, the commission exists. It follows its procedure as per the act. When it hands over the report, it becomes functus officio. And thereafter, Lordship, the records are available because they are ultimately handed over to the government. They are with us. Now, these multiple trunks running into thousands of pages, we are, of course, going to bring it to the notice of the court. But subject to what Lordship feels, we would feel that a case by case we'll have to do. Otherwise, it's going to be thousands of pages over multiple trunks. And we have also made a chart. And we
are you saying that there is no order sheet maintained by the commission?
Lordship, in fairness, I can't answer that. Because Lordship,
if you
thousands of pages. No, Lordship.
If you are not answering to that, then we can't help it.
No, Lordship.
You see,
Let-
it is for you to show,
Lordship.
yes, there was an answer, there was an order sheet maintained. I'm
No.
not asking for the trunks and trunks of files.
No, Lordship.
I'm only asking for
But
whether
Lordship,
there
we
was
need
an
time.
order sheet mentioned.
Lordship may hear me for a minute, just for a minute. We are not running away from assisting Lordship to go through that. But I'm merely pointing out that it is, Lordship, this procedure was not evolved by the government. The government has no role in the procedure and what the Commission of Inquiry does. Those records are available. We need time to go through each one of those for being able to answer what Lordship is asking. We cannot give you an answer in yes or no, Lordship, without going through these several trunks of thousands of pages. And we will need time. Bearing in mind, Lordship, respectfully from the
So
state's
therefore,
perspective,
if that be so, then are you conceding to the fact that there is a violation of section
not
8B
at
and
all.
8C?
Not at all. To the
Then-
contrary.
No, if you,
We will show-
no, Mr. Kohli, the thing is like this. You say that we are not in a position to make any statement to that effect as regards whether there was an order sheet maintained or not. This contains volumes and volumes of
It's a
so and so.
No, but
Now,
Lordship,
the
it's a separate
petitioner
body.
herein alleges that there is a violation of section 8B and 8C. How would the court look into it?
Lordship, the next question that will flow. When I am not the body that is doing this procedure, which is the government, I am separate to the commission. In fairness, Lordship, if I have to take a stand, I have to be given reasonable opportunity to study it, or in the alternative, without to assist the court so that I come clean. We can submit all of it and Lordships could direct us to do so. But we cannot pass a definitive answer on the procedure because we are not the Commission of Inquiry. We are the government. The Commission of Inquiry does not function under our administrative control. It is by a retired judge, Supreme Court, High Court, whenever it is, whoever it is, Lordship. They evolve their procedure. How can we say that they did not follow the procedure when I can argue to the contrary?
So
that,
you cannot also say that they followed the procedure.
So therefore, Lordship, that is a statement that would have to be on fact. As Lordship has noted in the order.
No,
that there is a
therefore, if that thing has not been produced, obviously this court will presume that.
Lordship, I would
So we
respectfully.
can, I think, dictate the judgment.
No, Lordship, I can respectfully say that to the contrary, that
You
Lordship, that presumption.
The violation of
commission-
section 8B and 8C.
No, Lordship, then Lordship may see the law. Please come
I
to
think
the.
the division bench, Mr. Kohli, will help you out.
No, Lordship, that though, of course, the division bench or the Supreme Court will help
no.
every appellant, whoever is before
I
that.
don't know, Mr. Kohli, I don't permit so much of indulgence. Indulgence is for the division bench. They are very kind judges, not me.
Lordship may come to.
Mr. Kohli, we are done with it. Now I think we can dictate. Now I will only say as to whether all these petitioners were issued notice
Yes.
and whether they have submitted a reply.
Yes, Lordship.
In the
And
reply,
also
which
they
has
have
been
inspected
given
the
by
documents.
Priyank Deka, he has said that this has been denied. He
Lordship
has
may see the
completely
report.
denied.
Lordship may need to
So
see.
thereafter, he says that I am not also involved in any criminal case. Is it a similar reply for all? Okay.
Lordship, I would respectfully say, Lordship may help
Well,
me.
show me
place
that
our reply.
Advani judgment. Let us complete it. Hearing
Lordship,
complete.
I would also like to respond on 8B.
No. If you are not, you cannot say that whether 8B and 8B has been
Lordship may-
complied with or not. Don't make this type of
no.
arguments, Mr. Kohli.
Lordship, please come to page
This can
92.
only happen in other courts, not before me.
Lordship,
You are very much at liberty to take it up in the division bench.
Lordship, in fairness,
I have heard
an
you.
officer of the
in
court.
fact, Mr. Kohli, I fixed the matter today because of
Lordship,
you.
and I'm
It
here
was
to
a
assist,
motion day.
Lordship.
And
I'm
you
here.
are not available. Only, anyways, you want to appear from there. It's very good.
The Lordship,
Okay, let us see.
Lordship may just hear me for a minute because I must submit for the state.
I've heard you.
No,
Very good.
Lordship, 8B is complied. That is my clear thing
Yes,
as per the
Mr.
settled law.
Chaudhary, which is the judgment you are referring to?
First, your lordship will have the Delhi High Court judgment, which is the first judgment on this point. Indira Nehru Gandhi versus JC Sir Commission of Inquiry.
8B.
ILR 1981 Delhi. That's page 1 of my compilation.
Just open our.
Yes.
If your lordships come,
Yeah, correct.
first.
Yes.
This was a case, my lord, where 8B violation was, my lord, urged before the High Court. And the High Court held, my lord, that 8B, my lord, is mandatory. Non-compliance, my lord, renders the proceedings what? Well, before that, will your lordship first come to page 22. running page 20, my lord.
Yes.
Towards the A, your lordship said, my lord, a person. Last two paragraphs, my lord, A, B, running page 20. A person, your lordship said that. A person whose conduct has been inquired into by the commission or is likely to be prejudicially affected by the inquiry must be given a reasonable opportunity of heard. That implies, please mark my lord, the right to cross-examine witnesses who deposed against him. Number B, such a person is given the right by section 8B to produce evidence in his defense. From the combination of these two rights, a sequence immediately arises. The witnesses against the person falling under 8B must be produced first, and he must be allowed to cross-examine them before he is called upon to produce evidence in defense. This also accords with the rule of evidence. I pause here for a moment, madam. The notice from the commission directs me to file my written statement, which means, my lords, the 8B notice has been asked to disclose his or her defense, which cannot be done. That's one, my lords, flagrant violation of 8B. Now, my lords, please now come straight to the operative part at 284. 284, my lords. And my friend, my lord, your lordship, last order directed that the records of the commission will disclose, namely the order sheets, which are not today. And my friend says, my lord, the commission is distinct from the state. Once the commission has submitted the report, my lord, the commission becomes functus officio. The commission no longer exists. The records are with the government, and the government says, my lord, the records are not with us. Now, please see today, 284.
Lordship, that is an incorrect
No,
submission.
no, no,
I
no.
must
He
protest.
does not
I have
say that
said
the record
records
is
are
not with you.
And my learned friend
No, no,
can't
Mr.
make false
Chaudhary,
imputations, Lord.
Mr. Chaudhary, Mr. Kohli doesn't say that the
Yes,
record.
commission
No,
is-
no, Mr.
Oh, I never
Mr.
said so, Lord.
Chaudhary, raising your voice does not make the change. No, Mr. Chaudhary, raising your voice in the court would not change the fact situation. The fact is here that he only said that, look here, we have it in trunks and trunks, but it is for us, we don't know whether it has been complied with or not.
Then I
That
say,
is his submission. Yes.
so please at 284. In my opinion, the last paragraph, my lord, in my opinion, there can be no doubt that sections 8B and 8C are mandatory. One might even call them statutory rules of natural justice, since they were not complied with within respect of Mrs. Gandhi and Mr. Mukherjee. The proceedings of the commission, please mark my notes, become void and ultra vires. The commission stepped outside its jurisdiction and lost its powers. Therefore, the chairman was not legally competent to administer the oath to Mr. Gandhi, Mrs. Gandhi and Mr. Mukherjee, asking them questions he was not exercising. Now, my lords, the next judgment, my lord, is off-cited, my lord, that's Kiran Bedi's judgment, my lord, versus the Commission of Inquiry, that's running page 289. 1989, my lord, there's that.
Yes.
1 SCC 494. And please come straight to the operative part, my lord, which I am going to rely upon. This was a case, my lord, where Kiran Bedi, your lordship, recall, my lord, the Tisazari court fiasco, where lawyers and the police, my lord, police lathi charged on the lawyers. A commission of inquiry was set up, my lord, headed by Justice Vatwa, and Mrs. Bedi was given notice under 8B. Now, let's please see the relevant part at page 307. Para 17. My lord, there's that. Consequently, we find it unnecessary to consider it any further in detail. The submissions made by the council for the parties on this point. Insofar as point 2 is concerned, it would be seen that the use of the words or between clause A and B, my lord, please mark, my lord, of section 8B of the Act makes it clear that section 8B would be attracted if requirement of clause A or clause B is fulfilled. Clause A of 8B applies when the conduct of any person is to be inquired into, whereas clause B applies in a case where reputation of a person is likely to be prejudicially affected.
In this case, there is already a subjective satisfaction of the commission. By the moment he issues the notice, he has the subject.
The committee in its interim report specifically stated that the conduct of these two petitioners, among others, was to be examined. Having once so stated in unequivocal terms, it was not open for the committee to still take the stand that 8B was not attractive insofar as they were concerned. Recourse to procedure under 8B is not confined, please mark this, my lords, to any particular stage, and if not earlier, at any rate, as soon as the committee made the aforesaid unequivocal declaration of its intention in its interim report. In this case, my lords, the order passed by the commission. it was of the view, as it seems to be, for which view there is apparently no justification, that issue of a formal notice under 8B was a sine qua non for effecting that section. At all events, the committee could not deny the petitioners the statutory protection of 8B by merely refraining from issuing a formal notice, even though on its own declared intention, the section was clearly attractive. Now, my lord, then it refers to, my lord, that Ghulam Muhammad's judgment, my lord. Then state of Karnataka, my lord, I'll place this judgment also, the constitutional bench judgment of the Supreme Court. Now, my lord, para 20. Keeping in view the nature of the allegations made in the statements of case and supporting affidavits filed on behalf of the various bar associations, including the High Court Bar Association, requirement of clause B of 8B was fulfilled in as much as if those allegations were proved, they were likely to prejudicially affect the reputation of two persons. Indeed, in view of the terms of reference which contemplated taking of stringent action against all those responsible, given the career of the petitioner that police officers are likely to be affected, in case any adverse finding was recorded against them. In view of the aforesaid specific term of reference, the principle that the report of a commission of inquiry has no force proprio vigore does not, on a pragmatic approach to the consequences, seems to constitute sufficient.
So here is a case where there was no notice issued.
Yes.
We are not here. Here there is a notice issue.
Well, your lordship has seen under 8B, there are two clauses. One, my lords, where you inquire into the conduct of a person. Or if the report of the commission is going to prejudicially affect the reputation of that person. In this case, my lords, both are triggered because the report ultimately.
No, Mr. Chaudhary, there is no quarrel with that proposition. It is the commission's subjective satisfaction that both A and B has applied. So
Applied.
there is no
I'm
quarrel
good.
with that.
I'm good.
So therefore, the only thing is what Mr. Kohli submits out here, that it is only a right to be heard and produce evidence. When it is a right to be heard, a notice being given and a written statement being submitted, that is enough. That is what is the contention of Mr. Kohli.
That is my
So-
respectful submission.
So that now the question is, you say that no. When you are asking me only to submit a written statement
Yeah.
against these allegations which are there in the FSL reports,
Yeah.
as it is your prima facie opinion or just on the basis of the FSL reports.
Yeah.
So therefore, if you ask me that, I will reply you with my stand out here. I have given it. There is further to be done out there to that effect, that the moment you take on record the inquiry or carry out the further inquiry on the basis thereof and take the evidence. Earlier it was only your prima facie opinion.
Yeah.
Now when the opinion becomes has to be based on not only on the FSL report, you have the power to summon witnesses. These witnesses must have been examined only for the purpose of educing these documents. The moment these are there, then at that point of time, the petitioner have a right to cross-examine.
Very great.
And this aspect is seen from section 8C, where there are two options. Either the petitioner may request, or as well, when any other evidence is being produced, it has to be looked into.
Yeah.
This is the wording of section 8C.
Yes, I'm grateful. 8CA, my lord.
You see, 8C, the appropriate government, comma, every person referred to in subsection 8B, and with the permission of the commission,
Yeah. Any other person.
any other person whose evidence is recorded by the commission. So therefore, any other person, if he is not a part who is 8B, so therefore he has to ask the permission. And otherwise, it is an inherent right of the person concerned to do it.
Yeah.
This I understand. Now tell me, which is the judgment for that?
Yes. Now,
Not Kiran Bedi doesn't help you.
Kiran Bedi talks about, my lord, that about the reputation part.
No, there is no quarrel with that. The commission also understand that the reputation would be spoiled, therefore issues the notice.
State of Bihar versus LK Advani, my lord.
Let us come to that.
322, running page, 2003, 8 SCC 361.
Page 320.
Running page 322, my lord.
Okay.
And if your lordship, this was, my lord, the Bhagalpur riots case, my lord, where a commission of inquiry was set up. And, my lords, the commission of inquiry, in breach of 8B, went and submitted the report. Now, my lord, please have at 327, my lord, running page 327 at the top. The case of respondent number 1, my lord, has that? My lord, has that?
Yes.
The case of respondent number 1 has been that such findings and observations recorded by a two-member report of the inquiry commission objectionable, painted him in the minds of the people affecting his reputation, bringing down his image. 5. The High Court, in our view, has been rightly cautious in observing that it was not concerned about the merit or the question of appointment or the recommendation of the commission, but it confined its inquiry to the parts of the report which, according to the respondent number 1, were objectionable, and it was necessary that he was allowed an opportunity before making any comment on his alleged conduct. The High Court, after elaborate discussion on the point involved, partly allowed the writ petition, ordering that such part of the report shall be inoperative and no action can be taken on the basis thereof. Now, please skip the page, come to 328.
Yes.
Para 7, my lords. The provisions contained in 8B of the Act quoted above was brought into the statute book by the amending Act 79 of 1971. It may be noticed that the amendment was brought about 20 years after the passing of the main Act itself. The experience during the past 2 decades must have made the legislature realize it would but be necessary to notice a person, please mark, my lords, whose conduct the commission considers necessary to inquire into during the course of the inquiry, or whose reputation is likely to be prejudicially affected by the inquiry. It is further provides that such a person would have a reasonable opportunity of being heard and to adduce evidence in his defense. Thus, the principles of natural justice were got inducted in the shape of a statutory provision. It is thus, please mark, my lord, incumbent upon the commission to give an opportunity to a person before any comment is made or opinion is expressed, which is likely to prejudicially affect that person. Needless to emphasize that failure to comply, please mark this part, my lord, with the principles of natural justice renders the action non-est as well as the consequences thereof. Now, then the next contention is the state said we have not taken any action on this, so the petition is premature. Court said no. Once there are any finding minutes, then page 330 minutes. The last 5 lines of page 330. There may be occasions where, after consideration of the report, the government may decide not to take any action against the person concerned. Yet, observation and remarks may be of such which may play upon the reputation of the person concerned in this aspect of the matter has been fully taken care of by clause B of the. So it is not.
Now, this is on the aspect that as the government has not taken any action. Therefore, why should you go into this aspect? The court says that when there is a reputation being involved, and more particularly after the judgment, the right of reputation, right of privacy, reputation has become a fundamental right.
Paragraph 8, your lordship saw, it is incumbent upon the commission to give this safeguard.
Understood. That is no quarrel with that.
Yes.
But
now, my lord,
but Mr. Chaudhary, tackle with this submission which is being made by Mr. Kohli. There's a right to be heard is a right to notice and reply and inspect documents and inspection of documents.
Yes.
And thereupon it was your duty to come and approach the commission to what is next to be done.
my answer is.
So answer is to be given by you on that aspect.
My answer is this. 8B, your lordship saw, my lord, it is a safeguard provided to a person. And that safeguard, my lords, will have to be given and enforced by the commission. I don't have.
Where is that? Which?
8B, my lord. Your lordship will have 8B. I'll come down, my lord, to Ashok positions.
Yes.
Division bench of Allahabad High Court.
Shall give
If
to
at
that
any stage
person
of the
a
inquiry,
reasonable opportunity of
commission
being heard
considers
and
it necessary to inquire into the conduct of any person. Your lordship will skip that. The commission shall give to that person a reasonable opportunity of being heard in the inquiry and to produce evidence. So it is incumbent, my lords, on the commission to give the protection and the safeguards under 8B to the person against whom, my lords, whose conduct is being inquired into. Right, my lords? Then 8C further substantiates this, my lord, that he has to give me a right of cross-examination of a witness, to address the commission, and to be represented by legal practice. Right, my lord? Now, my lord, alongside this, your lordship asked a very important query, my lord, last time, that on rule 52A, the notice under 52A. Right, my lord? Just come at the rule, my lord, 52A. I've done some research on this, my lord. There's a
commission shall as soon as may after
as soon as maybe after its appointment, right, my lord? Issue a notice to every person who, in its opinion, could be given an opportunity of a heard in the inquiry to furnish to the commission a statement relating to such matters as may be specified in the notice. B, issue a notification to be published in such manner as it may deem fit, inviting all persons Required to furnish the general notice. Every statement is marked. Statement notice has that statement. Even 2A also refers to a statement. 3 says every statement furnished under clause A of subroute 2 shall be accompanied by an affidavit. Then 4, every person furnishing a statement under clause A of subroute 2 shall also furnish to the commission along with the statement a list of documents if any. Right, Manoj? So 5(2)A, the lordships will just note, is at the time, at the inception when the commission is being constituted. The person referred to in 5(2)A is not a person referred to under section 8. 8B person is when you are inquiring into the conduct of the court.
His reputation.
Right now, grateful. 5(2)A says every person notice who in its opinion should be given an opportunity.
So therefore, it is 5(2)A is in respect to the which the commission thinks that these are persons who are there.
Yes.
So let us issue notice to them.
And call them.
And there might be many more who may
Yes.
like to say something.
Yes.
So therefore, we
To-
issue a public notice.
From the prima facie view.
So asking them whatever.
So,
And whenever they submit that particular document, it has to be verified by an affidavit so that there is some matter of a thing which can be ascertained
Yes.
or the importance can be given taking into account that it is on oath.
grateful. Now, please have now, alongside this, the notice of the commission at page 19. In my respectful submission, Millet, the Honorable Commission issued a notice under 5(2)A. And that I will make it good by some of the division bench of the Allahabad High Court. Page 92, your lordship, said, Millet. Though, Millet, it's overlapping with the fact that the commission is also inquiring into the conduct of the person. My lord, that's page 92.
So tell me one thing. Does the state of Assam have a rules? You have a rules, Mr. Kohli?
There are disciplinary rules.
Because you see, as per section 12 of the Commission of Inquiries Act,
Lordship.
the
Power to make
appropriate
rules.
government may by notification in the official gazette make rules to carry out the purpose of this act. Now the appropriate government has been defined in section 2A. In matters pertaining to the central government, relation of commission appointed by it. When the state government appoints a commission, it will be the state. Now, the state doesn't have rules.
Like when Tamil Nadu has rules. Tamil Nadu has my lord.
Or it has to be adopted somewhere.
No, these rules will govern them because otherwise, my lord, 8, your lordship will have section 8. The commission is free
Will be governed.
to devise its own procedure. your lordship.
So therefore, procedure to be followed. The commission may, subject to any rules that may be made in that manner, have the power to regulate its own procedure, including fixing of places, times, and so, decide here. So
Yes.
therefore,
Yeah.
in view of that, the commission has made its own rules. But it cannot go beyond 8B and 8C because this is
Yes,
has
Lordship.
been already held to be procedural in nature and it has to be
Correct.
required. Okay. So let us therefore not go to the central rules because the state rules will be there. We
In our
can.
case, I don't think.
Now, if the state doesn't have, then the commission will work its own procedure, but have to comply with 8B and 8C. Let us put it to the.
Also have section 5, I placed it the other day. 5(2). Because 5(2), will have to be connected with rule 5(2). The commission shall have the power to require any person subject to any privilege which may be claimed by that person under any law for the time being in force to furnish information on such points or matters as in the opinion of the commission may be useful for the relevant subject matter of inquiry, and any such person so required shall be deemed to be legally bound to furnish such information within the meaning of section 176 and 177 of the Indian Penal Code. So this person in 5(2), is not the person who against whom whose conduct is being inquired into on the.
No, it cannot be. It cannot be because this will come if there's a rules
I'm
are
very
there. Let us see the rules.
Yes. 5(2)A again.
And it won't be this also. There might be. This is for the purpose of evidence.
Yes. So,
Now, kindly see here the evidence of any who has furnished statement and so if after evidence the commission is satisfied for determining of any error, it may recall any witness subject to so and so commission may pay. Commission shall have the power, either personally or through a person of the commission have the power to regulate its own procedure in respect to any matter. Appointment of assessors. Okay. Then.
So, 5(2)A, your lordship saw, and along with 5(2), it refers to a person. This, my lords, has to be at the inception when the commission is formed, my lords. That is clear, my lords. From 5. The commission as soon as after its appointment. 5(2)A, lordship, seen that, my lord? Right, my lord?
Yes.
So 5(2)A applies, my lords, in a different segment. Read with section 5(2). 8B notice is, my lord, class in itself who does not fall under 5(2) or 5(2).
Now, obviously, it cannot be because why on earth the commission, the legislature would give it?
Now, please have page 92 of my list. My lord has that? Just have second paragraph. And whereas your answer scripts for CCE May 2013 conducted by the Assam Public were seized by the concerned investigating officer of Dibrugarh. So, my lord, it's referring to the petitioner. Then, my lord, whereas, please mark that during the course of inquiry, the following malpractices and anomalies are prima facie found against you. And if your lordships turn the pages, come to page 95. So, my lord, this is where.
Now, my question therefore is, you see, what is the malpractices found?
Yes.
One is the FSL report.
Yes.
The second is also the FSL report.
Yes.
Third is also the FSL report.
It's basically on the FSL report.
Now the question is, this FSL report, whatever may be, has to be brought on record by way of exercise of powers under 5A2.
5(2)A.
5A2.
Yes.
Thereby summoning and enforcing the attendance of any person and examine him. So a person will be invited out here and come ask him that how do you, he will adduce evidence that this is his signature. Maybe the strict laws of Evidence Act would not apply, but then also somebody has to endorse these FSL reports. It cannot be just the documentary evidence cannot be just given to him. Somebody who has the authority has to give it to him, saying that there is an authenticity to this.
If that's same, it has the power of a civil court. It's deemed to be a civil court.
That is what I
The
say.
commission is deemed to be a civil court.
Where? 5?
4. The commission shall be deemed to be a civil court. And when any offence as described under 175, 178, 179, 180, or 228 is committed in view of in the presence of the commission may, after recording the facts constituting the offence and statement of the accused as provided for in the Code of Criminal, forward their case to a magistrate having duty to try the same, and magistrate to whom such any case is forwarded shall proceed to hear the complaint against the accused if the case is forwarded to him under 46. then my lord, five, any proceeding with the petition will take this proceeding within the meaning of 193 and 220. So it's a civil court, my lord. They have the powers of a civil court.
But then also,
Now, my lord,
you cannot rely on the FSL report unless somebody endorses
I'm
it.
grateful.
The moment it is being endorsed by somebody,
Yeah.
it is the evidence taken.
Yeah.
And when the evidence is being taken, that cannot be taken ex parte
Yes.
without you. After
So
those,
once the evidence is taken and I am summoned under 8B, then I have a right, as a matter of right, to get the witness recalled.
to be not to be informed, that this evidence
Yes.
would be taken.
Yes. I'm grateful. Now, my lords, please have page 95, my lords, the last penultimate paragraph of this notice. Now, therefore, please mark this. You are called upon to respond to the above anomalies by way of a written statement. This, my lords, is exercising power under 528. That you come with a written statement. An 8P notice, my lords, cannot be asked to submit a written statement, because that would amount to disclosing the defense methods even before he has cross-examined the witness. That's what Kiran Bedi says. And there is a division bench judgment of our Lordship's court, my lords, which considered it, my lords, in the context of your Lordship's recall, my lords, in the early 2000, there were police firing in Tura and Williamnagar. So two commissions of inquiries were set up. One was Justice D.N. Chaudhary, Commissioner of Inquiry, one was Justice Barua. A matter came from the Justice D.N. Chaudhary, Commissioner of Inquiry, before this court. And your Lordship's, my lords, sitting in the division bench of this court, my lords, Justice Biswas and Justice B.P. Kotak. B.P. Kotak is welcome, has analyzed the 8P and, my lords, emphasized the law under 8P and what are the protection under 8P. But before that, my lords, from my compilation, my lords, please come, my lords, to the fourth judgment, my lords, page 331. This is, my lords, the division bench of Allahabad High Court. Justice Tarun Chatterjee and Justice Ashok Bhushan. Justice Bhushan judgment, my lords. And here, my lords, was similar case, my lords, a notice was issued. The court interpreted that this notice was under 528. Not under 8C. Lordships have page 331, my lord. Please see, my lord, para 2. By the writ petition, the petitioner has prayed for quashing the notification dated 26/9/23, 2003, appointing single member commission of inquiry. Another prayer which was subsequently added is to quash the decision of the state government as contained in the letter dated so and so, annexure 16 to the writ petition issued by Sri Ravinder Singh so and so, by which Sri Vijay Shankar Mathur was communicated about his appointment for submitting a report regarding prima facie irregularities found with regard to Noida, Greater Noida, Taj Expressway project. It has further been prayed that the entire proceedings and report of the inquiry commission be quashed. Please come to para 4, my lords. The inquiry commission commenced its proceeding. My lords, has page 332. Lordships has that. The inquiry commission commenced its proceedings on 1st of October 2003 by calling upon the state government as well as Taj Express Authority to produce entire documents, records relating to the project. The commission also issued a general notice that at 7/10/2023, calling the public in general to give information and materials to the commission by affidavit dated so and so. The general notice was published in various newspapers. Now, please mark next to the next page. Notice was also issued to the petitioner dated 6/1/2003, calling upon the petitioner to place its stand on 12/11/2003 with regard to the subject matter of the inquiry. Similar notice here. On 2/11, the petitioner's representative appeared, gave an application dated 12/11. Unless specific query is given on which petitioner was required to reply, it is difficult to place any stand. The petitioner also mentioned in the letter that this petition number 5133 of 2003 filed by the petitioner challenging the government notification is pending before the Allahabad High Court. The secretary of the commission by letter dated 12/11/2003 informed that the main question relating to the contract settlements of Taj Expressway project will be relating to concession agreement, and we will skip that. And now please come, my lords, to paragraph 5, page 333.
Yes.
Rakesh Dwivedi's submission, Mr. Rakesh Dwivedi, senior advocate appearing for the petitioner, made the following submission in support of the writ petition. Now let's please see 2. The commission, while submitting its report, has not complied with the provisions of 8B and 8C of the Act. No notice was given to the petitioner within the meaning of 8B. Though, by law, that notice was already there. Further, even if the notice dated 10/11/2003 does not comply, Rule 5 of the Commissions of Inquiry Act, Rule 1972, no reasonable opportunity was given to the petitioner by the commission. Hence, the entire inquiry is vitiated and the report is liable to be quashed on this ground alone. Please come, Malas, down.
But here, Allahabad High Court was taking into account the central rules.
Yes,
The
because in
cent-
UP also there are no rules.
So how can we take that rules?
So if the state has rules, the rules will apply. Otherwise, my lords, the central government rules which are there along with the act will procure we gotta apply, my lords, to the
How?
unless my lords, there's no bar, my lords, just have again just have the provision.
No. These rules may be adopted by the commission because taking into account that the commission has a right
Yeah,
to have its own procedure,
yeah.
it may say that, okay, we will follow, at the initiation, it may say that we will follow the central rules.
Yeah.
But otherwise, how do you say that the central rules will apply taking into account section 12 categorically mentions that appropriate government shall frame the rules, and section 2A says who will be the appropriate government, who are a commission set up by the central government and the state government.
Yeah.
So therefore, the rule 12, the central rules, in my opinion, would not, yes, this is an understanding as regards how the central rules will apply. And
Unless the state has
the
adopted-
court had also looked into it at paragraph number 15 of the sage judgment, and looking into it, it says that there contemplates two types of notices. One is a notice which is given at that point of time, and the second would be at the notice when there would be in a case of in the case of 8B, there is no contemplation of notice in the central rules.
100. In fact, no format is there, madam. There's no prescribed format.
Because it's not necessary, because the right is there. It is
Okay.
inherent right.
Yes.
Unless just for example, I was just thinking aloud of there in respect to the Code of Civil Procedure, there are certain provisions which says that a person may cross-examine with the permission of the court. May, just for example, let us take the provision of Order 18, Rule 17 of the CPC. If we look into it, a person may ask to give evidence, additional evidence which is there. But, or in, more particularly, let us come to the case of Order 26, Rule 10.2
Yes,
of the
commission,
CPC.
commission, yes.
Commission.
Yes.
So there, if you see, kindly see, read the language of that, Order 26, Rule 10.2.
The report of the commissioner, report and depositions to be evidence in the suit. The report of the commissioner and the evidence taken by him, but not the evidence without the report, shall be the evidence in the suit and shall form part of the record. But the court, or with the permission of the court, any of the parties to the suit may examine the commissioner.
So this is a cross-examination power is subject to the
Yes.
permission of the court.
Either the court cross-examines or any other person with the permission of the court.
And this power is akin to section 8C insofar
Other person.
or qua any other person,
Yes.
not 8B.
Yes, 8B has a right, man. 8B notice it as a matter of right. Has
But,
the right to
but there is a categorical judgment which says, pertaining to, I'm not finding it now, that day I've asked my clerk to look into it, that 8B, a person, no evidence, once you issue the notice under section 8B, thereupon, the moment you take up any evidence, you have to inform him.
Yes, in the presence.
If you don't inform him that we are going to take evidence, how can he have a right of cross-examination? Or in other words, it says,
The
you
cross-examination
cannot
will be-
record his evidence in his
His
absence.
Yes. That's
The- That is the judgment, I think, in the case of Bajpai, BAJPAI.
I will get back on that. But please have minutes when I'm on this judgment of Jayaprakash. At para 15. So the court rules, my lords, that this was not a notice under 8B. It was in fact the general notice asking him to give a statement on the information received. Now, 15 minutes, para 15 at 3:37.
Let's come to Punjab and Haryana judgment now, next.
That Bhupinder Singh Hooda.
No, I have understood that.
No, no, even Bhupinder Singh Hooda's judgment also says 8B is mandatory. Both the judges hold.
No, there is no quarrel that
Yes.
8B is mandatory.
you
There is no
violate
quarrel.
8B.
But the only thing is, what further action a commission is required to do in pursuance to the reply submitted?
May I say this? May I say this?
Because his because the commission in here has already formed an opinion
Then
that, look here, on these we find, these FSL reports, that there is a thing which will be touching on your conduct as well as your reputation. Therefore, I asked you to submit a written statement.
Yes, my lord.
So the written statement which he is asking for,
Yes, my lord.
in normally what happens in a case of a natural justice, you want to take any action against him which will have a civil consequences, you issue him a notice.
Yes, my lord.
The right to be heard has been also said by the Supreme Court to have a right to produce evidence also.
Yes. Yeah, my lord, the
If
provision
we
itself is
see the judgment, just for example, in that demolition case
the latest one.
given by Justice Gauhati,
Right, yes.
the right to heard also includes the right to produce evidence.
But
Now, how will a person know that you are exercising powers under 8B,
yes, my lord.
and therefore you have to assume that you can produce evidence if you don't fix a date.
Yes, my lord.
Now, if we look into section 5.4, another aspect,
Yes, my lord.
the commission will set its own procedure.
Yes, my lord.
Now, think about this another proposition. The Assam doesn't have the rules under 12. Rules are there of the central government. Central government does not say entirely the entire procedure, the rules. It only says how initiation can be done and all these things.
Yes.
But if this procedure is not there, and as the commissioner is under 5.4 is to set up its own procedure, then in that regard, isn't it required for the commissioner at that point of time also to fix what is the procedure to be followed?
What is it?
And if the procedure is to be followed in the case of 8B, there will also be mentioning at that point of time, a procedure has to be initially followed, that when the evidence will be taken, just for example, in sometimes this provision is 5.4 is akin to the provision of the Arbitration Act,
Yes.
wherein it says the arbitral tribunal shall formulate its own procedure.
Yes.
So when you have the arbitration proceedings initially, you find out that they take up the issue out there and say that this is
They
the
take the
procedure
schedule.
followed.
Yes.
Now here the commission comes or is confronted with an issue by which these documents prima facie disclose that itution is given, it will impact that particular person concerned. And as such, the commission issues the notice under 8B. It may not have been under the contemplation of the commission that it would be necessary. But then also there is a date fixed for the purpose of evidence. And the commission must have known that if we have issued the notice under 8B, there is a requirement of fixing a date
Evidence.
for evidence in
And the-
presence of that person concerned.
Yes.
Where is that intimation?
I mean, according to me, my lords, commission, my lords, under 8B when he proceeds, is not required, my lords, to even say it in so many words what is stated in the notice here, that this is all has come against him. All it has to say is that in the conduct of the proceedings before the commission, material has come before us, which require us to inquire into your conduct, or our recommendations or observations may ultimately impact your reputation. So appear before the commission, give a date for appearance before the commission when the person 8B notice appears. And then, my lords, the 8B notice may then ask for inspection of the records. But the safeguards under 8B has to be given by the commission. That's the mandate of the act.
Or one may also think it aloud to the effect, if you see section rule 5.2a,
Yes.
the commission is required to issue notice to whom the commission feels necessary, they would be necessary, as well as to the state government.
Yes.
By way, if this person is felt necessary,
Give information.
then you can identify him, you issue the notice to him by whatever post or whatever it may be. As regards others, there may be many more, so you issue a notice in
General
public.
notice. Whoever has information.
Yes, so this is what happens. But there you are asking them to submit a written statement on an affidavit. However, in the case of 8B, there is no mention out there that as regards 52A would apply.
I'm grateful.
So therefore, 8B says this person concerned would be now an interested person because his reputation is involved.
Summon him.
So it turns into a person like an accused.
Yeah, the lordship is right. He's an accused.
And therefore, he will, because his reputation is at
Because the Delhi
stake,
High
so
Court judgment-
therefore,
what
he
Delhi-
has to come and appear.
Yeah, he's an accused. That's what the Delhi High Court judgment says.
In
He's
fact-
like an accused.
In fact,
So
if
you
you
cannot compel him to disclose his defense.
because if the moment you ask him to disclose his evidence, it may affect
Yes.
his
So
cross-examination.
because asking for that written statement.
Ah,
violates
that
my
is
right of
also
accused.
violates
I'm
8B.
grateful.
It appears so.
Now let's please have a division. Lordship is getting up.
Oh, yes, 5 minutes, I'm
Yes.
coming back.
Wait, reason. Well, what I was submitting is, madam, that compelling my lords and 8B notice to file a written statement, madam, at the very inception, by calling upon the 8B who falls in the category of 8B to give her defense, madam, in my respectful submission, is infringes the right under 8B. Now, my lords, in that context, madam, will your lordships have a division bench judgment of this from the court, madam? I have sent a copy to Mr. Cole. Give a copy to-
We have it. Thank you.
Yeah. Well, a division bench judgment in 2007 1 GLR 319. Because lordships have, my lords, first. That is BP Katoki, my lords. Please have paragraph 1 first, my lords, which refers to the commission established, my lords, pertaining to the police firing, my lords, in Tura. And, my lords, here the commission, my lord, issued notices at the beginning, my lord, you will not see. Paragraph 3. The commission in its proceeding dated 28/2/2006 finalized the regulation of procedure to be adopted by it and communicated to the parties. By the said order, the district administration was directed to file examination in chief supported by affidavit as per regulation of procedure adopted by it, and further observing that the cross-examination of the witnesses by administration shall continue on a day-to-day basis. By another order dated 28/2/2006, the commission, upon perusal of the statement submitted by the parties and keeping in mind the nature of the allegations made in the statement of case as well as the examination of material on record made available to the commission, including notification dated 3/1/2006, passed an order directing issuance of notice under 8B of the Act to 4 government officials, namely so-and-so, Sangma, Marak, and so-and-so, affording reasonable opportunity to those persons who have been heard in the inquiry and to produce evidence in their defense. Accordingly, such notices under 8B of the Act were issued to this person. An application on behalf of the district authorities was filed before the commission with a prayer to recall, modify the order, directing the district administration to lead evidence at the first instance and to direct the public memorialist and other witnesses to lead their evidence. The commission, by order dated 4/3/2006, disposed of the said application filed on behalf of the district authorities by observing that the person to whom notices on the 8B of the Act has been issued would naturally be examined at the end of the inquiry. Please mark this below. And further directing that the district administration to file the examination in chief in the form of the evidence report. And also direct the memorialist to file the examination in chief in the form of affidavit. Now, the first petition transferred to the principal bench, apart from seeking a further direction to the commission to record evidence of public memorialist and all other witnesses in the first instance, and to permit the district authorities and his officials to read evidence in the second instance. Now your lordship will come to paragraph 24. Paragraph 24 at page 334. Considers 8B, lordship, paragraph 24. Section 8B of the Act confers a statutory protection to such persons whose conduct and or reputation the commission considers or for the opinion that is likely to prejudicially affect by the inquiry. Such person, under the said provision of law, has to be afforded a reasonable opportunity to be heard in the inquiry and to produce evidence in defense. The said provision, along with sections 8A and C, are incorporated in the Act by Act 79 of 1971, with the object of giving every such person the reasonable opportunity of being heard in the inquiry and to produce evidence in his defense. That is to say, to comply with the principles of natural justice before committing upon his conduct and or reputation by the commission in his report. The principle underlying such provision is that no person should be condemned unheard. Now please come to paragraph 30. Paragraph 30, at page 336. This is what the an answer which the lordships also said, my lords. Section, my lord has that. Section 8B of the Act does not contemplate issuance of any notice. It requires the commission to afford reasonable opportunity of being heard and to adduce evidence to such person whose the commission considers of the opinion that conduct and or reputation may be required to be commented upon in report to be submitted to the appropriate government. Any communication issued by the commission intimating such person giving such protection is neither a show cause notice as contended by the writ petition, the second writ petition, nor a charge sheet. But at the same time, the commission, before giving such statutory protection to a person, is required to form a prima facie opinion on the basis of the materials available on record. In the instant case, it appears from the records produced before the court that apart from the memorandum submitted on behalf of the district authorities, supported by an affidavit of P. Sampat Kumar, Deputy Commissioner, there were 20 other memorandums on affidavit filed by different members on 28/2/2006. When the commission passed an order considering forming an opinion that the conduct and or reputation of the writ petition, the second writ petition may be required to be commented upon in the report, and as such, given the protection under Section 8B. Neither 8B of the Act is marked as penal, nor any other provision of the Act requires to disclose the materials available on the record of the commission on the basis of which the commission considers it necessary to give the protection under 8B in the intimation given to that such person about giving such protection as discussed above. No notice is in fact required to be issued under 8B. What requires to be provided is an opportunity of being heard in the inquiry, which includes the examination of its witnesses in defense. Therefore, non-disclosure of the ground or the particulars of materials available on record of the commission, which is the basis for giving such protection, will not vitiate the order passed by the commission because of the right available to such person to inspect records or to get the copy of the material from the commission. As hailed above, 8B of the Act only contemplates this mark, a protection and not an acquisition. Then, my lords, if the lordships come to the next paragraph,
Yes.
I'm just reading the page 337, my lords, from Placetum C, the last 5 lines of paragraph 33. What has been done by the commission is giving such protection as the commission prima facie of the view that the conduct and reputation of the writ petition may require to be commented upon in its report. The commission has not in fact formed a final opinion that it will comment on the conduct or reputation of the writ petitioner or other persons to whom the protection under 8B has been given. Naturally, all opportunities have to be given to such persons to defend themselves in the said inquiry. Number 34. No doubt, when such a statutory protection under 8B of the Act is given, such person has a right to know what are the materials against him on the basis of which the commission may ultimately be required to comment on his conduct and or reputation in his report to be submitted before the appropriate government. But can it be said that non-furnishing of materials or non-disclosure of such ground in the notice, even if it is statutorily required, will render such notice section 8B invalid? Remember the last 4 lines of this page, such person will also have the right under 8C to cross-examine the witnesses other than the witnesses produced by him, and also to address the commissioner. The writ petition and the second writ petition, in fact, upon receipt of the information regarding the protection given under 8B of the Act, has appeared before the commissioner, participated in the proceeding without objecting, giving to answer. And minus para 30. This is my lord at page 339. The my lord has that.
Again, they have referred to some rules. Did the commission adopt these
Yes.
rules?
No. The commission devised its own procedure at the very inception of the
No,
inquiry.
kindly come to 36. Further rule 55A.
Further
of the
rule
rules.
55A of the this is the rule, man. The central
Understood. But the commission must have devised that, okay, we'll accept these rules. Because
I'm grateful.
in absence of the rules
Yes.
being made by the appropriate government, who have constituted the commission, then the commission may very well say, okay, the central rules will
We'll
follow.
adopt. I'm grateful.
Because he has, at the time of 8A, I suppose, or 8, he has to formulate the procedure to be followed.
Follow. Then, my lord,
And in fact, if you see these rules also, kindly see the rule, this one is 5(8).
yes. To regulate his own procedure.
When there is
Provision.
nothing mentioned in these rules.
For which no
So
provision is
when the rules are there, it will be rules. But in this case, there is no rules. Unless the commission says, which don't know,
I
I
don't know.
also don't know.
I don't know.
And Mr.
my lord,
Kohli
my lord, the
also
order sheet,
doesn't know.
the order file of the commission, my lord, is what will disclose. That will disclose, my lord.
So therefore, if it is not produced, that is to the presumption will be there.
May I address Lordship if my learned friend has finished?
No, my lord, no. Now, please also have paragraph 40. Reiterate, my lord, the law. And 42, my lord, are the directions which were. And please see, my lord, para 42.
But tell me one thing. Yes, the division bench must have stayed there, but tell me one thing. If at any stage the commission considers it here, the commission shall give to that person a reasonable opportunity of being heard.
Yes.
Now, this reasonable opportunity of being heard have been interpreted by the Supreme Court on various occasions to say that he has to also know what are the allegations against him
Yes.
when he appears.
Yes.
That is a proposition which is being settled also by the Supreme Court. And this language out here that the commission shall give to that person a reasonable opportunity of being heard. Yes,
It has to be meaningful.
it has to be a meaningful. Yes, what has been stated out there, these are the prima facie evidence. What do you have to
It is
say?
the allegation, yes.
These are the allegations against you, and this is the prima facie thing which prima facie opinion is there on these FSL reports. It would touch your reputation and such. What do you have to say? You may ask for a written statement, but the written statement is it is not a it is. But also one has to also understand that this is also the court is akin to a civil procedure court. So if it is akin to the civil court, he has a right to reply. So he has a right to reply. So he may not be in the dock as an accused.
There's a Delhi High Court judgment, which my learned friend is relying. There the Delhi High Court has said under the Commission of Inquiries Act that 8B notice is akin to an accused in a criminal trial. Because the commission is inquiring into the conduct, his bona fides. So he has to come clean. So when he comes before the commission, Kiran Bedi says that you cannot compel the 8B notice to straight away go to the witness box. 8B notice will first have the right to cross-examine all those witnesses who have deposed against him or her. After which, my lord, the 8B notice will then decide to go into the witness box. If it does not go, my lord, at his own peril. The protection which the court says is that if you ask him to disclose your defense at the beginning, because he's been called for a trial, he's been asked to come, he's been summoned, my lords, to appear before the commission, where the commission has prima facie found that there is material against you which I need to conduct an inquiry.
Like a criminal trial on prosecution.
And that's why, my lord,
No, if it is like a civil court, how do you adduce the evidence?
Sorry, my lord?
How do you adduce evidence? You may give a rebuttal evidence, it's a different thing. But how do you adduce evidence in your support without there being anything mentioned?
No.
Without there being anything
Lordship is
mentioned.
right. The division bench here says, Lordship is right. So once, my lords, the 8B notice is summoned, that 8B notice can appear before the commission and ask the commission, request the commission to disclose the material on the basis of which he has been given this protection under 8. But what is this material which I need to rebut? The allegation which has come against me. Then the commission it will be incumbent on the commission to disclose that this is the material. You can inspect the records. This is the material which has come. So and so has come and deposed against me.
No, he has said that in his notice. He has said
FSL.
no, not only FSL. You can inspect the records also.
Yes, no,
You can
inspect the
look
records
into
is
all
one
these
thing.
aspects of the record.
Inspect the records is one plus.
Hmm.
But it was incumbent of, with due respect, it was incumbent on the commission to summon the notice, to appear before the commission, and to lead evidence in his or her defense. Commission should have asked, you want to lead evidence in your defense? He had a right, my lords, to participate in the proceedings therefrom before the commission. In fact, my lords, I
Or you may say on the basis of not much going into the division bench judgment,
Yes.
one thing can be culled out that 8B is not an opportunity, but it's a protection.
it's a protection. Yes, it's a safeguard.
It's a
It's a
safeguard
statutory
of the
safeguard.
protection being given
And it is incumbent on the commission to confer that protection.
to, in that regard, the protection is being given for the purpose of as regards to safeguard his reputation,
Yes. No, my lords, may I say
which
this?
may result in view of the inquiry.
Now, what the commission has done, my lords. This is one aspect. These are persons my lord, who have been condemned unheard. They have lost their jobs today. They are suspended based on the commission's report, which is the subject matter of failure. What the commission has done is also facing. Some person came and made a statement against a few women officers. That statement, my lord, is ad verbatim recorded, my lord, in the commission. Right, man? Where, my lords, the character of those lady officers was slanted. Yet no notice is given.
Serious?
And the commission records, my lords, that person's deposition. That so and so came. This is what it was a free for all. Came and said this, and it's part of the report. Those persons, my lords, they've been castigated socially. They've been condemned unheard. They fall under 2B, 8B, the reputation. If I come and say something against my lordship, has a matter of right, has to be.
But they are not petitioners, yeah?
No, they're not. I'm saying that. What I'm saying is, madam, 8B and 8C protection has been flouted by the commission. And in my respectful submission, madam, since I place the judgment, the 8B and 8C safeguards are valuable safeguards. The lordship use the words protection. They are statutory protection conferred by the statute. And it is incumbent, my lords, on the Honorable Commission to give effect to those safeguards. I don't have to go and ask. The commission has to confer that safeguard. And that's the law. And the decided cases I pointed out, my lords, that if 8B and 8C is flouted, the report, my lords, is illegal.
Quoted person.
Quoted person. It's non-est, not binding, and all consequential proceedings thereafter are bad. That's the LCAT warning say. LCAT means all consequential actions are bad. You cannot take any action on the basis of that. Now, the last judgment I will cite, my lords, similar to our case, is a Madras High Court Division Bench judgment of 1981. And Manoharan, I have. This was, my lords, based on a report, my lords. Suspension order was issued, show cause notice was issued, court quashed it.
May I request my learned friend to share the citation?
Oh, yeah, I'm so sorry. This is actually a photocopy of AIR 1981, Madras 147.
Thank you.
Your lordships, if your lordships have, my lords, the second page, my lords, on the right, just above paragraph 2. This charge was purely based on the findings given by the Commission of Inquiry in paragraph 4.56 and 7.26 of the report. On service of the memo of charges, the appellant filed to read petition. Now, let's, please come now to the last page. Paragraph 6 on the left, if a lordship see, my lord, the last page. Therefore, second line onwards, therefore, that portion of the report which deals with the conduct and reputation of the appellant without giving the appellant an opportunity of being heard in the inquiry could be taken to be vitiated for violation of 8B of the Act. It is true that the report of the Commission of Inquiry has no legal force, property, or vigor, but however, it is seen in this case that the findings rendered by the Commission of Inquiry have been taken as the sole basis for initiating the disciplinary proceedings against the appellant. In these circumstances, the appellant is entitled to put forward his grievance. The Commission of Inquiry has given findings regarding his conduct without giving him an opportunity to put forward his defense and behind his back, and therefore, that portion of the report which deals with his conduct and affects his reputation cannot be relied upon by the state law. Then the last 7-8 lines from the bottom. Thus, findings rendered in paragraph so and so of the report of the Commission of Inquiry are in violation of section 8B of the Act and Rule 7 and 10. Please mark, my lords. Yeah, my lords, the Tamil Nadu has the rules. Your lords saw that, my lords. The Tamil Nadu Commissions of Inquiry rules. In that, the appellant was not given an opportunity to be heard in the inquiry, even though the findings rendered deals with his official conduct and affects his reputation.
So yes, 8B was not at all compliant.
Not at all.
Yeah, that's not a problem for that.
Now, my lords, your lordships have seen, my lords, the impugned so-called notice, the memorandum of charge is solely based on, my lords, the report of the commission. Your lordship saw that at page 48. Your lordship saw that of the just had that page 48. Lordship recalls, my lords.
No,
There is no dispute on that.
you see, there is one thing.
Yeah.
Based upon as the state have not shown anything to that effect
Yes.
as regards the procedure which has been followed by the state, by the year, which would have been there in the order sheet itself.
Yeah.
As well as what steps were taken pursuant to the written statement being filed, by the commission. So there would be a definite presumption to that effect.
Violation of 8B.
But the another question is, inquiry report is okay. The horse that they can still initiate
That
fresh
is-
proceedings,
But your lordship saw
on
that,
the basis of which they have initiated the criminal proceedings.
But if your lordship sees, my lords,
Because this is a report.
yeah.
Mr. Kohli, as I said on the last occasion also,
You did, Lordship.
even if the report goes, the recommendations may not be there. The recommendations normally is asking the government to look into it. This is what we have found.
Yes, Lordship.
So even on the basis thereof, without referring to it, you can very well initiate inquiry on the basis of materials which are there.
Lordship.
Now,
had-
the problem which I am saying is this: you need to do something more to that effect. If you have the 1964 rules, do you have it?
We have quoted the relevant one, but I'll open it online, Lordship.
Okay, take it out online. You see, Rule 9
Yes, Lordship, 9.
stipulates the procedure for the purpose of making the inquiry. Rule 9(1) is akin to Article 311.
Lordship.
Rule 9(2) says that a memorandum of charge would be formulated containing the statements of allegations, list of witnesses, and the documents may be given. It also gives, as per 9(3), a power or a right for making certain inspections. Then he files his written statement of defense. Then you see,
Oh,
an inquiry officer would be appointed under 9(4), the
And-
presenting officer under 9(5), if I'm not wrong.
yes, Lordship, I'm there.
So therefore, as of now, you have given the statement of allegations as well as the memorandum of charge only basing upon the B.K. Sharma's inquiry report.
Lordship.
But you still, on the basis, maybe, even on the, you may have got, maybe a thing may be illegal or may not be proper. The report may not be proper, violating so and so, but you have the materials. On the materials, there is no limitation when you can initiate the proceedings. So therefore, you can still initiate the proceedings, fresh proceedings, by doing it matter solved.
In fact, Lordship had even on the last stage said that that protection would be there so that the argument of double jeopardy would not arise. Lordship had been fair enough.
You
to
see, what
point-
I see on the, therefore I started with asking you, as mentioning about 3(4), that very inquiry proceedings which is there may have been submitted before the legislature placed or not, but it has to be given with an action taken report. The action taken report means some action has to be taken on the basis thereof, and it has to be placed so that the very idea, I think that's a 1967 or 57 judgment, wherein it says that in that circumstances, the legislature can debate on that very aspect. This is one aspect of the matter. But the horse that you still have, you are not having the criminal inquiry on the basis of the B.K. Sharma's report.
The B.K. Sharma, in fact, is relying on the investigation.
I'm saying you are not having a criminal inquiry, your basis of which you may be doing it. You mean you are going to prove in the criminal inquiry or criminal trial on the basis of the FSL evidence.
Absolutely, Lordship.
The evidence which will be tendered by those persons concerned, and in fact you must have done so, because this trial is almost over, I am told.
Yes,
That was a matter which was going on. The trial is over. So therefore, you have
It's not
done it on the basis
continuing,
of the
Lordship.
materials or those evidence which are being placed to that effect. You are aware that in respect of a criminal trial as well as in a departmental proceeding, the burden of proof is less.
Of course, I'm grateful for that, Lordship.
So under such circumstances, in view of section 9.2, which rule 9.2, which mandates you have to give those documents also, is it also the requirement that if you want to go further, when you are going to prove it, because it is only recommendatory, on the basis of this inquiry report, you cannot dismiss him. You cannot,
Which is why you have
can
the
initiate
disciplinary-
a departmental proceedings, but you cannot dismiss him on that. So you need to give more evidence to that effect. So these evidence has to be part in the list of documents which are being provided as
Yes.
per 9.2.
Absolutely.
We are not taking up the rightful steps instead of keeping these matters here. This would be the most easiest thing. Instead of getting an order from this court that you have not violated it, 8B and 8C, and squashing everything, again another problem arises.
On that, if I may,
In
Lordship.
fact, that day I was watching a movie. So it was a new movie pertaining to some American movie out there. So they had a very faulty problems in respect to a criminal trial. They dropped it and had another fresh one. There's no limitation out here. So anyways, you cannot succeed beyond 9.2 because of the document being not given. And therefore he cannot submit a fresh memorandum. A memorandum, a written statement of defense in a proper manner. And therefore, how can you inquire into this? You have not appointed, I don't think you have appointed an inquiry officer, because the inquiry officer will only come when he submits his written statement of defense.
In some cases, Lordship, I'm instructed to say that an inquiry
You
officer.
have given the statement of defense. Huh? Okay. Or they have given statement and saying what? What did you say?
Many places it is the plea that, the parallel proceedings are there.
The parallel is for Mr. K.N. Chaudhary.
Our
Okay.
stand in the written statement is very simple. We have appeared in the exam. We have passed out. I don't know what had happened.
It's a 146 minutes of the day. There, my lord, he said, we do not know what are the findings of the B.K. Sharma Commission of Inquiry report. We have not been given a copy of the report. Just have page 146. That, sir, I have been served with the so-called notice along with statement of allegation.
Lordship, each person was given the relevant extract related on for them. The
And
whole
the
report is hundreds and thousands of pages. So
Which is
obviously, if it concerns X, everything related to X has been given. If it concerns Y, everything related to Y has been given. Z, everything related to Z. But obviously, X has not received A to Z. They have received everything related to them.
I will also have page 103, my lord.
I'll, of course, whenever Lordship permits, also assist Lordship on 8B, 8C. Because I may have a contrary view to place for your consideration on 8B, 8C.
Huh?
That there is no dispute on the proposition that it's mandatory. But I will also satisfy Lordship that the argument being taken that it has not been complied from the perspective of what has transpired and the settled law, it has been. And 8C is not applicable because Lordship, no one was called for tendering evidence. So there can be no cross. So
So
basically,
you mean to say the commissioner had made the report on his prima facie opinion?
no, Lordship, I am saying based on the documents. Please see for a minute 8C. Lordship, it makes an interesting read.
Now, are you therefore saying there was no witness?
Which is what I'm saying. It is all based on the basis of the FSL report and the documentary evidence.
There's not a single witness.
Which is what I'm saying. They didn't. So therefore, when they keep saying we could get a right to cross-examine, they were not denied that. They were given, but there was nobody to take the deposition. So what would be the cross? If they wanted to bring somebody, they never said that they want to bring somebody.
So therefore, you say that there is no witness.
Yes, I'm saying, Lordship, it is all
So
on
how on earth did the authority, the commission of inquiry, the commissioner of inquiry decide? Mr. Kohli, you have also been practicing for all these years. Have you heard of commission of inquiry acting in this manner? I've never heard of it.
I
How a
must,
document
Lordship, I
concern
must in
would lie?
fairness confess.
Does it the
My
document
first-hand
would come in
account of
thin
Commission of
air?
Inquiry is this matter. I must, in fairness, confess. This is the first
If
matter.
that is the procedure followed, then I think the entire commission of inquiry report should be honest.
So, but Lordship, I would also.
Documentary evidence have been taken into consideration without knowing who is tendering.
No, Lordship may just for a moment.
Or is it on evidence on affidavit?
Lordship may bear with me for a minute, just a minute. There are only 3 judgments and approximately 2-3 paragraphs each. That would also make it clear what is the Commission of Inquiry, what is 8B, 8C, and the third aspect, which is what happens if a person to whom the notice is sent, they don't respond, including the judgment my friend has that.
Okay, show me those judgments. Which are the judgments?
Yes, Lordship may please come in our compilation, Lordship. I'm told it is there, Lordship. My colleague Dipankar Nath or someone would be having a copy of it, Lordship. Can you open my judgments? Yes. Only 3. A 7-judge bench, which settled what is a commission of inquiry. So, Lordship, it's a compilation. Munmi madam has. I think Lordship has got it. It has various propositions, Lordship.
Okay.
So Lordship may straight away come to page 58.
Page?
58, which is the state of Karnataka versus Union of India, Lordship. Once Lordship is on 58, we will know if it's the same one.
Okay.
Mr. Kohli, can we also have a copy? If you can
Of course. We are just sending it on WhatsApp.
You're instructing
colleague
lawyers
is-
to carry copies. Give me a copy.
You just organize it.
Yes.
Lordship, that's 1977 4 SCC 608. Lordship may come straight to in the para number 184, which is at page 157.
Page?
157, Lordship. Bottom of page 157.
Okay.
It is clear. This and the next pages talks about what is a commission of inquiry. It is clear from these provisions and the general scheme of the Act that a commission of inquiry appointed under the Act is purely a fact-finding body which has no power to pronounce a binding or definitive judgment. It has to collect facts through the evidence laid before it, and on a consideration thereof, it is required to submit a report which the appointing authority may or may not accept. These are sensitive matters. There are sensitive matters of public importance, which, if left to normal investigational agencies, can create needless controversies and generate an atmosphere of suspicion. The larger interests of the community require that such matters should be inquired into by a high-powered commissions consisting of persons whose findings can command the confidence of people. In his address, so and so, Lordship may just come to the middle of what is on the tribunals of inquiry. There is a sentence, 3 sentences down that says, no doubt this rarely happens, but from there, when it does, it is essential that public confidence should be restored, for without it, democracy cannot survive, can no longer survive. This was the principle. Now, next paragraph. A police investigation is at its very best a unilateral inquiry into accusations, since the person whose conduct is the subject matter of inquiry has no right or opportunity to cross-examine the witness whose statements are being recorded by the police. Section 8C of the Act, on the other hand, confers the right of cross-examination, the right of audience, and the right of representation through a legal practitioner on the appropriate government on every person referred to in Section 8B and with the permission of the Commission. Lordship may go five.
No. And with the
I'll read.
permission of the commission on other person whose evidence is recorded by the commission.
Then the next sentence.
Yes, Lordship. But so therefore, I'm reading further. We are only at the moment on what is a commission of inquiry. So, Lordship, if we come 5 sentences from the bottom of that paragraph, after all,
Mr. Kohli, can I request you to read the next sentence? Clauses.
I'll read the whole thing. Lordship. Clauses A and B of Section 8B refer respectively to persons whose conduct the Commission considers it necessary to inquire into, and persons whose reputation in the opinion of the Commission is likely to be prejudicially affected by the inquiry, which my learned friend is arguing. It is undeniable that the person whose conduct being inquired into, and if he is a chief minister or a minister, the doings of the government itself are exposed to the fierce light of publicity. But that is a risk which is inherent in every inquiry directed at finding out the truth. It does not, however, justify the specious submission that the inquiry constitutes an interference with the executive functions of the state government, or that it confers on the central government the power to control the functions of the state executive. We may mark then, Lordship, after all, it is in the interest of those against whom open allegations of corruption and nepotism are made that they have an opportunity of repelling these allegations before a trained and independent commission of inquiry, which is not hidebound by the technical rules of evidence. It is only by establishing the truth that purity and integrity of public life can be preserved, and that is the objective with which the Commissions of Inquiry Act seeks to achieve. Para 185. In so-and-so case, it was held by the Nagpur High Court that Section 4 of the Act merely clothes the Commission with certain powers of a civil court, but does not confer on it the status of a court, and the Commission is only fictionally a civil court for the limited purposes enumerated in Section 5.4. The court observed that there is no accuser, Lordship, that's important, no accused, and no specific charges for trial before the Commission, nor is the government under the law required to pronounce one way or the other on the findings of the Commission. In other words, the Commission, governed by the Commissions of Inquiry Act 1952, is appointed by the state government for the information of its own mind. It is therefore a fact-finding body meant only to instruct the mind of the government without producing any document of a judicial nature. These observations were extracted and quoted with the approval of this court in so-and-so. It is therefore clear, the last part I am reading in this judgment, that the power conferred by Parliament on the central government to appoint a commission of inquiry under Section 3(1) of the Act, and for the purpose of finding facts in regard to the allegations of corruption, favoritism, and nepotism against a sitting chief minister or ministers, cannot be held to constitute interference with the executive functions of the state government. On receipt of the Commission's report, the central government may or may not take any action, depending upon the nature of the findings recorded by the Commission. If it decides to take any action, the validity thereof may have to be tested in the light of the constitutional provisions. But until that stage arrives, it is difficult to hold that the central government is exercising any control or supervisory jurisdiction over the executive functions of the state government. So this 7-judge bench broadly enumerates what is a commission of inquiry. Now, Lordship, let us see the next 2 judgments. And if Lordship would be so pleased to come to the next judgment, which is PR Nayak, which is at page 211. Delhi High Court, Lordship. It's an old judgment of 1973, Lordship. And Lordship may come straight to page 247, bottom of the page. Where Section 8B is quoted. 247 at the bottom, Lordship, is 8B. 248, Lordship, may come. I'm merely showing after considering 8B, what does the court hold? I'm reading the paragraph on 248. It is implicit. Has Lordship got that? Page 248. Second para.
In this case, Justice Beg was the majority.
It's a two-judge bench, Lordship.
No, there were many judgments out here.
Yes, Lordship. Yes, of course. The Chandrachud judgment, that is the majority. Yes, Lordship. Absolutely.
Whose judgment was this? 185.
Yes, Lordship. So back to page 58, Lordship may note that the majority was Justice Chandrachud, Bhagwati, Untwalia, Shinghal, and Jaswant Singh. And then Lordship, Justice
Justice Chandrachud was concurring.
Yes.
Yes, Lordship. So we have shown you the concurring of the majority view. 5:2, Lordship, it was. The core issue was, Lordship, it was a commission of inquiry against the Chief Minister. So
Now, if it is, therefore, we can put at rest the question of accused here itself. If this court, this is by whom?
what I read was from
Beg.
Justice Chandrachud.
Justice Beg judgment is 186. This is by Justice Chandrachud.
Chandrachud, Lordship.
So the say Beg judgment says here,
Judgment starts at page 625.
concurring, consequent upon here. So it is not the main judgment. Okay.
Chief Justice.
And does that Justice Beg look into this aspect? As regard what is the commission of inquiry?
We'll let you know, Lordship, just in a moment, because this was the extract we decided, which was only on what is a commission of inquiry. My main propositions will flow from the next two judgments.
It's okay.
I'm just going to check it now. Let's open it. Starts at 70, yes.
Concurring. Basically, whether central government's notification is valid or not, because it was in US government inquiring into the affairs of the state.
Chief Minister. It was an original file.
Supreme Court. While answering the referent, the claim koi dise na.
Okay. Okay, then.
Lordship, we'll also continue seeing that. Lordship may just come to now PR Naik, Lordship, which is the next judgment at 211. 211. It's a 1973 judgment. I'm quoting, Lordship, only a couple of paragraphs. If Lordship would be pleased to come to page 247 bottom is section 8B.
At the time of the judgment, 8B, 8C was there.
Yes, Lordship. 72. Lordship, the amendment was, substantive amendment was 72, this is 73.
He was inserted in 71 after the Law Commission recommendation.
So, Lordship, H,
Yes.
where Lordship may note on the left is the placentum H.
You're
Then-
referring to page 247?
Yes, Lordship, bottom of the page, where it's at placentum.
If at any stage of the inquiry.
No, Lordship, bottom. Before that. Then it is contended that notices under section 8B were issued to various persons purely on the basis of the affidavits of Chaudhary without determining their relevancy or the question required to be determined under this section. Then section 8B, Lordship may come to the next page.
Yes.
Below that, it is implicit on 248. It is implicit in this section that notices thereunder have to be issued in the absence of a person whose conduct is being inquired into or the person whose reputation in the opinion of the commission is likely to be prejudicially affected by the inquiry. The commission has therefore to proceed on the basis of the material before it. At that stage, the only material before the commission was in the shape of affidavits filed by the government, Indian Refineries Limited, Indian Oil Corporation, and Chaudhary, amongst others. Here the material is the FSL, etc. Lordship. As we have stated already, the commission was of the opinion that if the government affidavits alone were to be taken into consideration, there will be hardly anything left to inquire. Therefore, the commission was justified in taking into the consideration the affidavit of Chaudhary, wherein allegations regarding the conduct of various persons were made. As a member of the public, he had to appear in response to the initial notice issued by the commission and taken up the burden of adducing facts in relation to the terms of reference which involve an inquiry into the conduct and or reputation of various persons. Now, please mark, Lordship, we do not see any reason why the commission cannot be said to have been justified in taking the allegations in the affidavit of Chaudhary as a basis for issuing these notices, and this fact alone will not establish that there is no application of mind by the commission before the issue of the notices under section 8b. Most important for us, this section incorporates and embodies the rule of natural justice not to condemn a person without affording him an opportunity of being heard. It is open to the person to whom a notice is issued not to avail of the opportunity afforded to him to appear and produce evidence in his defense, in which case his conduct and reputation will be inquired into in his absence. Then next part, Lordship, the language of section 8b does not suggest that any detailed reasons have to be recorded other than such as have been recorded by the commission before issuing these notices.
Only for the purpose of 8b.
Yes, Lordship, 8b.
Only for purpose of issuance of 8b.
Yes, Lordship. But Lordship, in terms of the issuance, the response comes, our case will be they responded, they even inspected. But they've kept quiet after that. Nayak says, if you keep quiet after being given the an opportunity, it is at your own peril. That's the crux of the judgment.
Now, why the matter came up before the Delhi High Court?
Lordship, it was related to an old contract related government affidavits. It's not relevant in facts to us. I'm only on 8b.
Mr. Kohli, I have a habit of looking into the facts a bit.
So, Lordship, where the facts are very relevant, I also...
No, because the submissions which are being made out there...
Please come to page...
No, if you see the submission, just for example, let us see the submission out here, the last part here. Lastly, page 251.
Yes, Lordship.
It is contended the commission exercised powers under 6b without prima facie satisfying itself about the necessity for issuance of such notice, issuing notice without clarifying the points to be answered, and issuing them in a discriminative manner. It appears that by so and so all of the three parties too, the inquirer had filed their written statement and where necessary, replication in respect of all this there. It is therefore submitted on behalf of the government that the stage referred to in demand has been reached and the person who were subject matter of allegations should be given reasonable opportunity of being heard in the inquiry and to produce evidence. The commission then considered the averments on affidavit and rejected the submission that there was no material to justify issuance of. It then recorded the names of the person whom the notice were under section 8b have to be issued and shall. On so and so, the commission made another order from which it appeared that it considered names of various persons. So and so, so and so, so and so.
Against whom?
And the reputation has been made by the Chaudhary for the purpose of sending in notices and therefore it does not appear from this order that the petitioner objected to any of these matters for any reason. It is therefore recorded that the petitioner prayed that similar notices should be sent to some more parties besides that of so and so written statement, and it is further clear that so and so, it is recorded that so and so, so and so.
Then the next page deals with the allegation of discrimination also. I'd say.
And the standard is that his submission to issue section A note to the concerned ministers was rejected by the commissions and therefore notice under section 8b were issued in a discriminatory manner. Okay, anyways.
Now, Lordship, the third judgment is at page 255, Lordship.
Yes.
Now, Lordship, this K. Vijay Bhaskar Reddy versus the government of Andhra Pradesh. This is an AP High Court judgment, Lordship.
What did it say?
Lordship, just para 2 is dealing with the former chief minister of the state. But the main paragraph that I'm relying on, Lordship, would be at page 47. 47, page 40, para 47 at 275. Page 270, para 47.
That a notice issued by Commission on the alia is vitiated as being vague and for want of material particulars and is violative of.
Yes, Lordship. This was the argument. And then, Lordship, it deals with the notice, and Lordship, para 49, Lordship, may come, which is at 276 bottom. And the holding paragraph that I will rely on is 51. Para 51 is very important, Lordship.
Yes, that is what I am reading.
Yes, Lordship. No pro forma notice is prescribed under the Act. Reference to the material should be made. That's the important point.
If you come, Mr. Kohli, this is what I said. At page 278, the first line.
Yes, Lord. If the material
which form the basis of the opinion by the Commission is not clearly indicated in the notice, the very purpose of giving a reasonable opportunity would be frustrated.
Fair, Lordship. Absolutely about that. The Lordship.
And then the addressee of the air would be placed in wilderness. Therefore, it has become necessary that what materials was taken into consideration by government while forming the opinion that the reputation in the air, that's the materials here. So this is what materials being referred to in the notice under so and so.
So therefore, Lordship, the material is referred at page 92 of the notice of the petition, which we've shown, Lordship. That is something they have seen, they have inspected. They've responded also, which is at page 95 or 96, Lordship, of 97, Lordship. Some gave a second response also, Lordship.
Now, kindly come to page 55, paragraph 54.
Yes, Lordship.
Therefore, whether
from the above, it follows
which are likely to prejudicially affect the reputation is not referred to in the notice under 8B, and thus the petitioners are not told of what they have to defend and what is the material on report which they have to rebut to safeguard their interest and to save their reputation.
Yes, Lordship. In our case, it's referred.
Notice affording opportunity of being heard, granting 15 days time, the petitioner are justified in expecting that the further inquiry would not go on during that period, and commenting that the collect material which would prejudice the interest of the addressee till the expiry of the specified period in the year. But for the above reasons, in our view, the proceedings of the Commission during that period cannot be held to be vitiated and cannot be declared as null for one, or the notice under say can be given at any stage of the end. It would have the open to the inquiry to give notice under section even at the closure of the inquiry. In as much as we have come to the conclusion that the notice in as much issued to the imam are vague because of the area, and so which, if accepted, would prejudicially affect the reputation and are not referred as I shall examine the materials affected, and was the opinion of going that there is material affects the reputation, it shall refer such materials in the notices under so and so and serve the same on the petitioner giving them reputation. Okay. Then
now, Lordship, and our case would be that, and therefore I'll come to that in a moment. Page 92, Lordship has seen all the material that's being relied on is referred. The response is a simpliciter denial. They go inspect it also. So there is no denial. So those notes, everything are there. We are at a much higher footing, Lordship. Now, Lordship, I just wish to say, there is one judgment that my learned friend relied on, which was the Lordship District Administration Tura. In that, Lordship, para 35. 34, my learned friend had already read. But I'd like to read from 34, 35, Lordship. Para 34 in the district administration Tura versus the Commission of Inquiry.
Yes.
Lordship, so para 34, 4 lines from the top, but can it be said? May I read from there, Lordship?
Yes. I remember.
Can
paragraph
it,
34.
yes, Lordship, but can it be said that non-furnishing of materials or non-disclosure of such grounds in the notice, even if it is statutorily required, will render such notice under Section 8B invalid unless prejudice caused is shown? The answer, in our opinion, is in the negative. That's what they were holding. And then it says, the person who complains about such non-furnishing of materials in the notice and or non-disclosure of grounds in such notice must demonstrate the prejudice caused to him for such non-supply, non-disclosure. Person to whom such protection under Section 8B of the Act has been given can approach the Commission for supply of the materials available on record. Such persons, during the course of the proceeding of inquiry before the Commission, will also know what more materials, if any, is there before the Commission. Para 35, Lordship. Just below placid term B, the writ petitioner. Para 35.
Yes.
The writ petitioner. May I read, Lordship? The writ petitioner and the second writ petition could have very well approached the learned commission to supply the materials available before it, which necessitated the commission to pass the order giving protection under 8B of the Act. It is always open to the petitioner, as well as other persons to whom the protection under Section 8B of the Act is given, to approach the learned commission to supply the materials available before it at any time of the inquiry, and the commission in that case is duty bound to supply such materials. However, if the records are voluminous, the commission may, in an appropriate case, instead of supplying the copy of such materials, allow such person to inspect the materials. So, Lordship, our case is the material is referred. They are also given a chance.
No. Which paragraph you are reading?
Para 35, Lordship, of the Tura.
338.
338 is the internal page, Lordship.
Yes. Where?
And I'm at placentum B at page 338.
Para 35.
Yes, Lordship.
Yes.
So it starts with the writ petitioner in the second writ petition.
It is always,
Yes, Lordship.
is always open to the
Yes, Lord.
petitioner as well as the other person whom the protection under Section B is given to approach the learner to supply the materials available at any time of the inquiry, and the commission is, this case, is duty bound to supply such materials.
Next.
However, if the records are valid, the commission may, in appropriate case, instead of supplying the copy of the materials, allow such persons to inspect survey and to take some. Such course of action will satisfy the principles of natural justice, and in that case, such person cannot raise a dispute that reasonable opportunity of being heard is not afforded. In this instant case, for the aforesaid reason, no prejudice has been caused to the petitioner in the second writ petition.
Yes, Lordship.
Yes.
Now, Lordship, we have prepared a chart. My learned colleague in the court will share. Where, Lordship, we have laid down all the names of the petitioners and pointed out when was a notice issued by the, which we say is a Section 8B, because no pro forma is given, whether a reply was filed, yes, no, and particulars of the inspection of records before the OMC and whether the same has been suppressed in the petition. So our case is, Lordship, yes, the commission wrote to everybody. Many of them replied, majority in the first round, all. Then, Lordship, several were given an opportunity. Everyone was given an opportunity. Several inspected, some did not. Several have even suppressed the fact that they've inspected it in their petitions. It says particulars of petitioners vis-a-vis the charge sheets and the OMC report. So it's a kind of a table with all information. It's not given, I think.
So, this is only for the purpose of opportunity of inspecting the documents.
Right, Lordship?
There is no quarrel out here by the petitioners that the commission gave the opportunity to inspect. It is already there. They are not on that. But did you My only question, Mr. Kohli, you have such information which has been placed before this court. Did the commission take any evidence? My only question is this.
Yes, Lordship. And therefore, Lordship, I'm sorry.
Was any witness there before the commission?
Which is
Or
what
did
I
he
was.
believe only on the affidavit filed by the state government?
So therefore, Lordship, what I was only placing, and it was only for Lordship to consider, is I was pointing out that in this time, Lordship, because there were several trunks, we have not had the opportunity to see all of it. Because ultimately, this was what the commission did. We have the trunks with us. We have thousands of pages. We just need a little more time.
It will be categorically mentioned. There are two things. In the commission's report, I have not looked into. I have also not looked into it.
It's
You
filed.
must have looked into it.
And Lordship, it's mentioned from page 6 of the report.
No. In that, is there any reference to a witness, oral evidence?
On the report, Lordship, would Lordship just keep it till tomorrow morning for me to come back to you on this, even though we can't see all the documents?
No. It cannot be at theory. We fixed the matter taking into account that from Manipur you are coming today before this court.
Lordship, I couldn't travel. I'm not.
This is a motion day, so
Yes,
therefore,
fine.
Mr.
I'm
Kohli, next
grateful
time,
and I'm
out here in
indisposed,
my
so I had to
court, there is
cancel
very
Manipur also.
clearly mentioned seeking adjournment in respect of any listed matter on behalf of learned senior counsel is not permitted.
I am not, Lordship. I've read that.
This
And
is
that's
my
why
rule,
I'm
how
before
I
you online.
operate my court.
Lordship, I am before you online.
I can fix the matter tomorrow, but the fact that whether you are there or not, it is immaterial for me.
Of course, Lordship.
I only regard the advocate on record who is there. I
It
can
is
hear
there. I've
him
read it.
dispose
I've read
of. But that is not the case. Tomorrow, it's not possible.
Well, fair
The
enough,
only
Lordship.
thing is here,
That's
I'm
good.
only asking you, was there any witness how the commission in the inquiry report, because the inquiry report has not been placed before us, so
It's filed, Lordship. now.
whether the commissioner had taken into account any oral evidence pursuant to the notice being issued. My only question is this. And the commission, did the commission formulate any procedure?
So therefore, Lordship, on the first answer, on my instructions, it is that the commission did not take any oral evidence from anyone. It was based, it no oral evidence from anyone. It was based on the material before that. The material was shared in terms of the 8B notice, referred to the material, inspection was there.
Mr. Kohli, can you tell me, whatever may be, when a commission has the power to call the attendance of a witness, the commission told them, no. Somewhere, with some newspaper, inside the newspaper, one FSL report has been sent in. Is it something like that?
No, Lordship. Then I must read something, Lordship, by permit, while we
Otherwise,
are.
how on earth did the commission accept? Yes, the commissioner might get the FSL report from the affidavit.
So, Lordship, I am reading, if you will permit me for a moment, the Commission of Inquiry report, which has now been placed, also, Lordship, it is filed already. May I just read with your permission, Lordship? Irrespective of the criminal proceeding and the persons involved herein, the Commission has independently and meticulously perused the materials available on record, which include the criminal investigation case records, forensic science laboratory reports, the answer scripts of the main examinations, and the other relevant documents which are already available with the Special Court Assam Gauhati, in which the criminal trial against the charge-sheeted persons allegedly involved in the anomalies and malpractices in CCE 13 and 14 is going on. Additionally, the Commission has also procured records of the documents, comments, views of the APSC, maintaining the judicial discipline of audi alteram partem, all the persons with the slightest of involvement in the alleged
You are
anomalies.
reading from where?
Page 32 of the report, Lordship, which was filed yesterday.
Of the report?
Yes, Lordship.
That report is not us.
Is there, Lordship? It's not attached to the period, but it's there in the court, Lordship.
It has been filed?
Yes, Lordship. That's what I was saying. I couldn't file the annexures.
We were handed over a copy at lunchtime.
You got it?
Yes.
See?
It took time to scan it, but we've not been able to succeed with the annexures.
Then the matter is over. No problem. Okay. Copy of the report of the commission for the combined, copy. There are two. You fall under which one?
The first, this
2013.
4th April 2020. 4th April 2022.
No, 13 or 14?
13, Lordship.
13. Okay. Let us
Page bottom of the is the page number. Would Lordship come to page 32? Page 32 of 645. Second panel. It starts lordship in bold, irrespective of the criminal proceedings and the persons involved.
Yes. Section 33 evidence act.
There was no sitting of the commission, I suppose.
There was lordship.
Mr. Kohli?
Oh, there was lordship.
There should not be a sitting because it seems everything he called it.
Yes.
He called the,
IO.
no IO.
Call the IO.
IO was called lordship. He was called.
That
Surjit Singh.
No, he treated the IO like a peon, I suppose. Because he never discussed the evidence of the IO.
No.
This is assist us
No, assist means assist, no, these files were being brought in.
for
No,
petition.
Basically, perusal.
he directed
And-
the government in the Home Department, Home and Political and the IO. And they have produced, so that is the material.
Ah.
Which is why, Lordship, in the beginning, I had said, Lordship, right at the start, that it's an independent statutory body and did not function under the administrative control. So, Lordship, that is, they devise their procedure.
Not
We can't
heard.
comment on that much.
Huh?
Including the criminal case record, 764.
Criminal case records with trial has.
The commission has prepared this report.
Huh?
Please see 764, madam. Foot of the page,
764.
last three lines.
7.
It is on the page.
It's a 645.
7?
64. Running page, your lordship said.
Towards the bottom, middle.
Summon it is on the basis of the above materials, including the criminal case records, and the responses of all concerned, the commission has prepared. Now, my lords also have page 987, sorry, 987. There were some persons who came and deposed. Some persons, my lord, pursuant to the notice, public notice, some persons came, just have page 797, chapter 7.
797.
Yes, ma'am.
And those are commission's evidence. We never cross-examine anybody.
Where?
797, chapter 7, my lord. During the course of inquiry and also pursuant to the public notice issued by the-
797 where? 797.
987, sorry.
987.
987. Very sorry. Chapter 7 and not chapter 10.
Yes.
During the course of inquiry and also pursuant to the public notice issued by the commission, some written responses as briefly discussed above have come to the commission. In such written responses, various allegations have been made alleging fraud and malpractices in CCE mains 2013, citing various examples given to the extent of highlighting the roll number, names and marks obtained. The respondents have highlighted various anomalies indicated below. Please make below, madam. In the written response filed by the organization, fight against injustice of APSC. This is a self-styled organization represented by so and so. Apart from highlighting the anomalies of the preliminary examination already discussed above, has highlighted the purported anomalies of the mains examination, also with citing instances such as LS deprivation of Papuri Deka with roll number so and so by heading 9 marks, which is secured against 1B. It is LS that this candidate has secured 763 and so on and so forth. Then, next page, madam. 988. The last paragraph. This organization has also submitted a list of rank-wise marks of all selected candidates of CC. According to them, some candidates got abnormally high marks, particularly in general studies. It relied upon Melons.
So they replied, these were must have been on affidavit, I suppose.
Sorry, Melon.
Are these not on affidavit?
Don't know.
No,
In his written response. Let's see again.
so the written
Must-
response,
under
if we
5.2
go by,
Under 5.2
it has to be on affidavit. So it becomes a form of an affidavitial evidence.
million.
So there is no evidence. How is it possible? Like a writ petition, huh?
Lordship, the findings of the report deal with the material that I just read out a short while.
That is why, my lord, trial court exposure is very, very important, my lord. In all sense of responsibility.
Shocking.
And making
Yes.
trial court exposure থাকা মানে বলবো কি কেউ নকরে।
So the reliance upon any evidence on affidavit,
Yes.
any response on the basis of an affidavit
Yes.
would be evidence.
That means, my lord, this was commission's evidence.
Yes. Which commission obtained.
Then now it was duty to give it to us. We'll cross-examine. We'll lead our evidence at later stage. So there is a brazen violation of 8B and C, my lord. I don't think any scope to argue on this case is open and shut now.
And Melon, the Pura judgment paragraph which my learned friend read, the challenge in the second writ petition was to the protection given under 8B and 8C. Which the court said that no, that already the protection has been given to you. The order was passed, declaring them as 8B notices. You go and appear before the judge.
Even in that Karnataka case,
Karnataka case also said.
7 judges bench, that is also in our
a
favor.
distinction-
Now, just for example, 844. Look at this. These are not these persons. These are persons, nah?
Hmm.
I saw this particular person's name somewhere.
Which person, Melon?
You see, as pointed out by a large number of could not be, now kindly see 795. 94, yes, 94. Which the candidate referring had stated in his written response dated demand that but for the anomalies of the wrong official's answer script, he had given the list of a candidate has also alleged that upon scrutiny of the marks secured by the candidate, it is found that some of the candidates secured as high as so and so. The candidate he above was preceded by another detailed response dated Iman in which he had given the details of anomalies. After declaration of the results on it was found that there were many wrongful answers and so and so. The candidate has contended that because of such wrong answers noticed in so and so, some students got abnormally high marks in general studies and also in optional subjects. Significantly, and as pointed out, the so and so who got 392 out of 400 was so and so. As pointed out, being large numbers of candidates could not appear in so and so as a fall of so and so. Now let us see a copy of the written response of AI is annexed as Annexure 5 in volume 2.
Don't think those annexes are part of the.
Not there, na?
That is what I'm saying, Lordship. These annexures are yet to be filed because they are in several trunks, 300 annexures. So what is filed is the report.
So if this document has been, this is not based on evidence, not based on affidavit. It has to be.
Of course, Lordship.
If any document is taken, it has to be based on oath because it is otherwise the mandate of law also. So it is
Without
evidence.
saying, Lordship.
When it has been taken note of. Now, where these reports, my question is whether these reports, now you have shown me the judgment of Andhra Pradesh High Court, where he said all other things are not required, but these things has to be made a part of it. Whether these reports of these persons concerned, which have been referred to in page 797 onwards, have been apprised to these persons concerned in your notice. Mr. Chaudhary argues that it is not required. But you say that it is required. Then how do you take care of it?
Lordship.
We do one thing. We'll hear again.
Tomorrow,
I'm very, not tomorrow.
the lordships have a category of top of the board, you can.
I have another matter. I have to take Mr. A. Samua's matter. Where is he? I have to take his matter.
Now,
Yeah, I'll take him.
Lordship will indicate a date later in the order.
When do you want? Not as per you, obviously.
I have not
Yes,
even
Mr.
request,
Dean,
Lordship.
what is your convenience? Not as per your senior counsel.
Lordship, I didn't even make
No.
In
You are
fairness,
not here pursuant to this year being granted. When do you want it? Okay, it will be. I will be available on 21st of February, Saturday. No, let's do it on 7th of March.
18th, your lordship is available.
Huh?
18th of February.
No. I'm not. These other dates are there. On 7th of March, Saturday.
Grateful.
The hearing remained inconclusive, and under such circumstances, the matter is directed at the consent of the parties. Matter is fixed on 7th of March 2026, Saturday.
Grateful, Lordship.
Grateful. The interim orders to continue.
Interim orders
Great.
past the list
all
will
the cases,
continue
sir.
till the next.
Very grateful.
Yes, Mr. S.S. Roy, what have you got out here?
Lordship, my instruction says that this was done in terms of a demarcation application was filed. One demarcation application filed before the Palasbury Circle Officer. Then when he came to demarcate the land, he found that this falls between two circles, Ajra and Palasbury. So he take the help of Assam survey officers, and after geotagging, it was been demarcated. They only demarcated it Then the person, Lordship, whose favor, he has barricaded there.
Who has put the barricade?
That the person who demarcation was done.
The person, the barricade was put in presence of these
No,
officials?
they only put the circle officers in the, with the help of Assam survey, they taking the geo coordinate, they put the points.
Pillars. They did not go for any barricading.
No,
So this barricading has been done subsequently.
subsequently.
My lord, may I see the photographs?
Photographs.
Police personnel are present. And the
And my, and
demarcation notice, my lord, will find at page 34. And date was fixed on 8 January. And all these things were done on 6 January.
And what is this? This at page 39? Who are these people present?
These are the person who disposes with the help of the officials. See, the police personnel are also present.
Kindly come to page 37.
For demarcation so much.
You say that at a later point of time, the demarcation has happened. And after the demarcation where these pillars were being put, which is
Lordship.
the normal rule, you say that thereafter the things happened.
Lordship.
They did it, those persons concerned.
Thereafter, they filed,
But why the police is there?
Lordship, thereafter, they filed an affair, Lordship. They filed an affair and the affair, non-affair case has been registered, Lordship.
Then,
It was under one.
and who is this lady at page 44?
Page 44. I'm told my lord, sir, he's an advocate. I don't know the name.
Who's advocate?
There,
So they have got the advocate also. Anyways, we do one thing, we can't help you. Now this particular boundary which is being put, now what is your problem now? You cannot access.
everything is stopped.
Then how are you inside?
This is disposes from the land, Lordship.
No. They were only dispossessed from a part of their land.
Lordship.
Their land is already there.
There.
Their dispute is some boundary.
Boundary dispute.
There is not anything else.
And the
So
next
therefore,
week-
there is a dispute involved. But the question is as to whether the access has been access. Are they not in a position to ingress and egress?
That instruct.
They stopped everything there. There is a iron gate pillar that has been closed, and we have come now. Just the side of that iron gate, we have taken a small route. Through that we are coming.
So you, therefore, you obviously you have to come. Otherwise, who is going to file the writ petition?
No, right, my lord. But the thing is that our gate has been closed.
Lordship.
Inside the campus, there is a guest house, my lord. Not guest house, PG, paying guest house.
But you have a way of coming out.
Yes.
Okay. Then
Lordship,
we
there was a
can't do-
hearing, the
We do
hearing,
one thing. Anyways, the matter is what happened in the, before that
it was
ATC?
fixed next week, Lordship, because
When?
next week date was not given, but it will be said by Tuesday, it will be.
Okay. Okay. We issue notice
Lordship,
fixing it on next Friday.
Lordship.
Next Friday, can you would not be able to serve these people, na? You
Lordship.
serve them by Dusty,
Yes, sir. Dusty will not, if they may.
because otherwise your matter can't be taken with urgency.
Right.
Or we have it on 29, 27.
But in the meantime, if Lordship orders them to remove the barricade from my
Lordship,
gate.
there's a boundary dispute and the matter.
But Mr. Samwa, isn't it the allowing the final relief?
Yes.
Why?
Because final relief will be on then only when the entire Miller things has been removed. But
You want this
Housing
court to
only
be the
means,
civil court.
Cloud
You want this court to be the civil court for recovery. Go and file before the civil court. Why you not filing a suit before the civil court?
the instruction.
We will look into only as regards if there is any constitutional thought taking into account that they have acted high-handedly. That is the only thing I am going to look into it. As regards delivery of possession, you go and before the civil court.
Happened, my lord. Because without serving a notice, there cannot be a demarcation.
Who asked for demarcation?
Why not? No.
You asked for demarcation.
But
Then,
No,
when you are asking for
that-
demarcation,
this was-
this person did not come according in person to our demarcation.
Mr. Somwa, this is what you are saying. We don't know whether it is true or not.
Then that is at page 34.
I can out here. I would then also not look into on the basis of this and give you this type of orders. Whatever you are now using it, we use for another 2 weeks. We'll look into that. Don't worry. Things I will make it ready. But if you don't serve them, this is the problem. Let me ask, what is the
Let them come up with the entire evidence that has to be that they followed, the procedure they followed before doing this. That is required to be followed under the law. Right? Be it in the case of maybe this is a
Mr. Samoa, I hope you know, I know what is the procedure to be followed. Demarcation, by way of demarcation, a person cannot be removed by these revenue authorities. I also know. If they have removed you, that is wrong. But for recovery of possession on, you have to do something else. Go to the civil court. This is not a court. I cannot allow them to hand over the possession to you unless I come at that these police officers as well as the district administration was involved in doing it. If that be so, then I can pass an order for restoring your possession. Not on any other aspect.
that is what we are playing.
Okay. Okay. Issue notice making it returnable on 27th of February 2026. Mr. S. Roy, with the revenue, anybody?
R. Borpujari,
PR Monto.
yes.
Ms. PR Monto accepts notice on behalf of the respondent number 1. Mr. S. Roy accepts notice on behalf of the respondent number 2 to
2,
speak
3, 5,
and
6,
13
13 and 14.
and 14. Full stop. Accordingly, extra copies of the writ petition be served by tomorrow. As regards the respondent number 7 to 12, the petitioner shall take steps by way of speed post by tomorrow. In addition to that, the petitioner is given the liberty to take steps by way of the stay routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that in pursuance to certain boundary dispute, the petitioner sought for a demarcation so that the boundary dispute can be resolved. However, to the shock and surprise of the petitioner, the private respondents number 7 to 12, along with the various officials, that is the circle officer Azrar, that is the respondent numbers, DC came. DC also came.
Well, this is officials, government, DC personally.
No, has DC come? No. Only 5 and 6 came. 5 and 6 along with police, who else?
Police from the Ajara police station.
Along with the respondent number 14, representative employees, police officials from the Azara police station came over and evicted the petitioner from a portion of the petitioner's land. Mr. A. Samua, the learned counsel appearing on behalf of the petitioner, further submits that as per the Assam Land and Revenue Regulation 1986, as well as the notifications which have been issued by the state government, it is made clear that it is only the duty of the revenue officials is only to show at the time of demarcation only to indicate the land and nothing further. However, in the instant case, the said respondent authorities have taken the law into their own hands and thereby dispossessed the petitioner. The learned counsel for the petitioner further submitted that they have also put a thatched barricade, thereby disturbing, thereby prohibiting the petitioner's ingress and egress to his own land. And it is under such circumstances the petitioner has been compelled to approach this court. Mr. A. Samua, the learned counsel for the petitioner, further submits that the respondent authorities not only dispossessed the petitioner but also disconnected the electricity, and it is only at the request made by the petitioner before the Chief Minister of Assam, the electricity have been restored, and the proceedings have been initiated by the co-district commissioner.
It was
of
on his
Jalukbari.
application it has taken.
Huh?
It was on his application.
Okay. He says that because of the Chief Minister said. See, I never said. Co-district commissioner of the Jalukbari co-district. He further submitted that though the matter was fixed yesterday, but the matter could not be taken up, and in the early hours, and it was informed that another date would be fixed. He therefore submitted that certain interim directions may be passed so that the petitioner is in a position to ingress and egress to his land. First, this court inquired with the learned counsel appearing on behalf of the petitioner as to how the petitioner approached this court by filing the affidavit if his ingress and egress have been restrained from his home. He submitted that there is a narrow path which have been allowed, and thereby the petitioner could approach his contact his lawyer and therefore approach this court. Taking into account the above, this court directs the respondents, more particularly the respondent number 3. Polasbari and Azra will come under 3.
Lordship.
Huh?
Lordship.
I mean,
Lordship.
Respondent number 3 to submit an affidavit in respect to the incident alleged by the petitioner by taking appropriate reports from the respondent number 5 and 6 who were admittedly present at the time at the time of demarcation. Full stop. The respondent number 13 shall also 13 and 14 shall also apprise this court by way of an affidavit, by way of instructions as to what steps have been taken as regards the FIR which was filed by the petitioner. Full stop. This court further observes that without giving the notice upon the respondent number 7 to 12, without having an opportunity, granting an opportunity to the respondent number 7 to 12, it would not be in the interest of justice to issue directions thereby for removal of the thatched barricade. This aspect this court shall consider on the next date.
Lordship, only thing.
Azara police station come under metro. So directions to file the affidavit may be given to both the deputies. Because both.
Okay, 3 and 4, na?
Lordship, the official of respondent number 5 was there, not the circle officer. Official Latmandal and SK was there
Not the circle officer.
Of the circle.
Officials of both Azara and
No,
both.
on the circle officer of Palasbari was there, and circle officer's official was there, Latmandal and SK of Ajra revenue. The circle officer Ajra was not present that day.
Direction may be given.
Both the deputy commissioner, that is respondent number so and so are directed to obtain to file an affidavit in respect to the dispute in the instant case after taking the inputs from the respondent number 6 and 7.
3 and 5 and 6.
5 and 6.
5 and 6. Lordship.
And Mr. A.R. Bhuya, another matter of yours. Huh? I do. Mr. Bhuya, production is Mr. Wait, your matter is the last because you didn't learn. Pati. Yes, Mr. Bhuya, what is your matter?
My lord, I has just started, my lord, installation of a my lord, diagnostic center in the private respondent numbers force about apartment in the building. My lord.
Ah.
Now, my lord, that building had the my lord NOC from the GMDA for G+1. And wherein, my lord, the agreement has also been executed with me, with the, my lord, as the owner of the building.
Yes.
Now, my lord, that once the agreement has been executed, my lord, I had carried out the construction work, interior works are going on. As this is, my lord, some norms are required to be followed, my lord. Now, suddenly, my lord, I have received with a notice, my lord, a copy has been served to me.
Who are you?
My lord, I am the tenant of that building.
Why is the owner not coming?
My lord, the owner is, my lord, old and he's some.
No. Owner has to be made a party.
I have made a party, my lord. I have made a
Owner is made a party.
Huh?
Owner is made a party.
No, not respondent, petitioner.
Respondent. Here it's a respondent.
No, he has to be a petitioner
Yes.
because of at his instance you have come.
my lord.
And what right do you have?
My lord, because my
No,
livelihood.
Mr. Bhuya, you have no right out here unless the owner comes in. You may build whatever you may take on rent something and make a beautiful palatial thing out there. But the fact that if it is illegal, it's illegal. It has to be demolished. How can I help you?
No,
You cannot say anything. What is your ground that it should be rejected?
no, my lord.
Why should we stay this operation?
My lord, the operation of the ground, my lord, which I have said that, my lord, that this area they have said that this is a, my lord, green belt area. The my lordship has sometime may have visited this Kanaklata Park, my lord. This cycle track is there, my lord. In that area they have said that this is a green belt, but along with my building, my lord, all the buildings are there with G+2, even G+3 structure are also there. It is just an open road, my lord. So therefore, my lord, this is a green belt they have issued, but I have not found out any notification notifying the area as a green belt, my lord. Now, if my lord may be pleased to peruse the impugn order, my lord, which is at page 52, my lord.
Sealing.
Sealing, my lord. They are now going to seal the entire building, my lord. If
What is the reason for sealing? What's the so cause?
Page 52, my lord, in
As a site inspector conductor revealed that following place of construction, Konoklata path, so and so manner of construction, RCCSB plus G plus 2, type of construction of SB so and so on green belt, violation of site setbacks and norms, temporary structure on southeast, cantilever projection beyond permissible, construction of staircase attached in so and. Now, therefore, you are hereby directed under so and so building here. Now, there is no building permission for that.
no building permission was there, my lord.
Where?
That document I could not.
Here not annexed with that
Then
building. permit.
how do we look into? Why should we give you?
No, my lord. It's filed so.
Mr. Bhuya, I understand everything, but unless you make him a party, it is he who has committed the fault. Because of that, you may be entitled for damages from him. But you are not you don't have a right out here if the construction. If you had constructed, it's a different thing out there.
My lord, what has happened?
Anyways, it will be sealed only, not demolished.
Not demolition.
Okay, seal it. We'll look into it next week.
My lord, kindly, my lord.
No.
The problem is that.
Mr. Bhuya, this does not happen. You have to seal it. You have been given a notice, let it be sealed. In the meantime, let it be sealed, but don't demolish it
Lords,
till the next date.
only ceiling is there. After only ceiling, say, not
Only sealing. Do the sealing. We'll look into it on the next
Later on.
date. Don't
But my
demolish.
section 85 of this 88 of the GMDA, my lord, says that it is the power of demolition, not the power of sealing. I have gone to section 88.
Mr. You should be happy with the sealing.
My lord, that is correct.
There are provision of appeal also, my lord. Section 7.
No. Mr. Bhuya, you should be happy with sealing.
Yes,
If they go for
demolition.
it will be more disastrous for you. But however, I shall pass an order that not to demolish
My lord,
because
may
you
I
never
say, my
know.
lord, that the unauthorized structure, if any, my lord. beyond the permissible limit, that may be sealed, my lord. But the,
No.
but the knots, my lord, which we have followed, that area may not be sealed, my lord.
So that,
That can be done, my lord.
well, if Lord say allows me, I can hand over the planning permit.
Yes, yes.
Planning permit says this is a residential area, he is trying to do business there. Planning permit. This is the planning permit.
And I'm very strict on that, Mr. Bhuya. I stopped one building something.
Oh, my lord. This NOC permit is under Pradhan
Then the
Mantri's.
GMDA wanted to help them. Then I asked that CEO, asked him to appear. After he appeared, then I asked him why you are not sealing it. Then they sealed it out. And as of now also it is sealed. Kailipara?
No, my lord, it's still running their business. That I
What?
Yes, madam.
After they sealed it.
We sealed it.
Was
they
it
are running their business. That
order
hotel,
passed?
that hotel order was passed to demolish, but it was not executed, still there. That I should not.
NK Hotel,
NK Hotel is
What happened to that?
it's running, my lord.
it has converted from the hotel to some residential apartment.
No. It has been converted. They said
They wanted guest house. That's also I said no, nothing doing.
they are running it, man. I know it, they are running it.
Why is the GMDA not doing anything?
My lord, that case is pending, my lord. That I am not appearing because I don't have to say it because initially I was the counsel for the petitioner, my lord. But later on,
No, but the matter was part heard before me, then somewhere it
No.
went off.
Yeah.
Anyways.
Lordship will see that particular NOC, my lord, planning permit. Lordship the top, my lord, issued under
That is
Mukhya Mantri.
No,
Gram-
but, because of that, why shouldn't we stay this?
No, Lordship will. This is a separate issue, my lord. This is
No,
a
this is
separate.
also the same.
No, this is a separate issue. Will that say action.
Nothing, no heavens will fall.
My lord,
Let us see.
Lordship will see. This is a residential. They will be trying to do business, my lord.
So what? There you are in a residential means you are
No, Lordship will
permitting
not-
somebody else in spite of strict orders passed by court.
My lord, they are.
Then also if you are allowing that, why
Thereafter, my
should
lord, in that particular case, my lord, thereafter orders were issued, my lord. The necessary orders were issued, my lord.
What?
That necessary orders were issued to demolish the building. There are some other petitioner has come and before the court, my lord. Persons who will be affected, they have come before the court.
No, persons were not affected who came. It is the owner who came over.
No,
Earlier it was somebody else who
Yes,
had
my lord.
come over.
Lordship will, this is separate different, my lord. This is Lordship will see.
I think.
Mukhya Mantri's Gramin
Hmm.
Nirman Yojana, my lord. This is
Don't
residential area, my lord.
Anyways, he has a problem medical, na?
No.
Diagnosis. What will
Business-
happen? The blood, where will it go?
My lord, business is going on, residential. Still not
Oh,
that,
it has not started.
because
Does
that's why Lordship.
Interior works requested a huge amount of money.
Mr. Dan, you don't have a case. Then you are not affected also. You ask for them because of that. Anyways, issue notice making it returnable on 23rd of February 2026. Mr. Esbora accepts notice on behalf of the respondent numbers 1, 2,
And 3.
Extra copies of the writ petition be provided by tomorrow. As regards the respondent number 4, the petitioner is directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein claims to be a tenant of the respondent number 4. You are saying that you are running a business.
I just started to meet the individually required, that business has not yet started.
Then why have you written out here?
Page number 46, Lordship, can you turn to page number 46? Trade license has been taken out.
No, license, but operation has not started.
It is the case of the petitioner that the petitioner is a tenant of the respondent number 4 and have started a business in the name and style of MS Anand Super Specialty and Diagnostic Center in a building standing over a plot of land which covered by DAG number 683 and Patta number 555, holding number 114-97520 of North Boma Revenue Circle village in the district of Kamrup Metro. So, Mr. Esbora, appearing on behalf of the petitioner, has categorically, respondents have placed that a building permission was granted to the respondent number 4.
My lord, planning permit, my lord.
Planning permit was granted to the respondent number 4 for construction of residential reuse only. Be it as it may, the respondent number 4 have not only violated the planning permit by giving the rent to the petitioner, on rent to the petitioner for carrying out a business, but have also violated the various norms as would appear from the show cause notice issued to the respondent number 4. Full stop. Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be prejudiced if certain interim directions are not passed, taking into account that the petitioner had invested a huge amount of money on an assurance given by the respondent number 4 that he can start a business. It is the opinion of this court that if there is a violation being committed to the provisions to the various to the provisions of the Gauhati, this is done by the Gauhati Metropolitan Development Authority Act 1985, as well as its building bylaws. And there has been a different use, and the building is now being used for a purpose for which the permission was not granted, unless and until such building, such conversion is permitted by the authorities, the carrying out of the business from the said building, which is only permitted for residential, cannot be allowed. Under such circumstances, this court is not inclined to pass any interim orders at this stage. However, the respondents herein are directed to file their affidavit, produce the instructions on the next date, that is 23/2/2026, as to so basing upon the said instruction, this court shall further consider what necessary orders can be passed. It is further observed that no, not against. Mr. A.R. I should not mention. If I say I will reject it, then you demolish it. Yes, Mr. Sensua, your matter. Yes, what is your case?
0.31 acre, my lord. Was originally purchased by my father. Says subsequently it was under DAG number 79 under Papier number 452. Subsequently it was renumbered as DAG number 78 of Patta number 411.
So your sale deed contains tag number 78 and 79, isn't it? 78 and 94.
78 and 90.
Okay, then
However, in this Jomabandi, my name has only come in this particular DAG number 17.
then
My lord, thereafter what has happened, there is some dispute as regard to a possession of that particular plot of land between two parties. Initially, I have gone and filed a title suit, which was subsequently withdrawn during pendency of the title suit. Some other party has told that the land which I am possessing is originally belongs to them, and there is a road in between which they were using them. So I withdrew the title suit, my lord, and again I went and
with liberty.
No, that there is, my lord. I did not get any liberty, my lord. I did not procure anything. However, when I filed the second petition, my lord, that was dismissed on under section 11 as the first application I was.
Section 11 and
without liberty.
section 12. I think it should be section 12. Anyways, it was done on the 11th. There cannot be a res judicata concept because of the fact that when there is no decision, where is the res judicata?
That is under appeal.
Huh?
That order is
That will come under section 12.
But however, it has been.
Anyways, whatever, then
Now, subsequently, what has happened, my lord, as there was a road in which is the respondent authority are now planning to construct through my land, my lord, land which is in my possession. So, my lord, I went to the respondent authority and told them that this is a land which is in my name, this is my father's name, and if you want to acquire that particular plot of land, you go through the legal process, whatever is required. But without giving any hearing to me or without listening to me, my lord, they have started measuring the land and they are started digging the land, my lord, digging the road, my lord, in fact. That is my case in.
Okay. Madam, we issue notice, short
Lordship, yes.
notice. Don't do anything till the next date. Let the circle officer submit a report before the court as to whether the land wherein there is a proposal for going ahead with some construction of a road, as per the materials on record, is their land, or how the executive engineer or how the PWD have been handed over the land for construction.
I will also take.
Issue notice making it returnable on 25th of February, possible? 25th of February 2026. Ms. S. Sharma appears on behalf of the respondent number 1,
2 and 3.
2, and 3.
Yes, 4.
Mr. S. Roy appears on behalf of the respondent number 4. Extra copies of the writ petition be served upon the councils by tomorrow. It is the case of the petitioner that his father had purchased how much land? Had purchased
0.318.
0.18
katha, 12 chataks.
Had purchased 18 katha, 12 chataks of land at Porgona Egarasti, Moza Rotham, Part 3, Old Dag number 79, Khotian number 452, New Dag number 78 and 94, Patta number 411.
Lordship, I have received instruction in a form of parawise comment.
Okay.
The job is not yet started. It is a preliminary state. They visited the site only.
It's okay. No problem. Let us get that instruction from there. I'll record that. Full stop. It is the case of the petitioner that the petitioner is in possession of the said land after the death of his father, isn't it? You are in possession. The grievance of the petitioner herein is that the respondent authorities are taking steps for constructing a road within the land of the petitioner. That too, without carrying out any acquisition proceedings. The learned counsel appearing on behalf of the petitioner had submitted that the petitioner has no objection if the said land is acquired from the petitioner or any acquisition proceedings is initiated for the purpose of construction of the land. But to dispossess the petitioner without initiating any procedure, without following the procedure established by law for construction, would be in violation of Article 21 of the Constitution, Article 21 and Article 300A of the Constitution. Taking into account the above, this court therefore directs the respondent number 4 to provide the instructions as to whether any steps are being taken for the purpose of construction over the land belonging to the petitioner. This court also takes note of the submission made by Ms. S. Sharma appearing on behalf of the respondent numbers 1, 2, and 3.
Yes.
To the effect that although the area has been inspected,
Yes.
but there is no steps being taken for carrying out any construction. Taking into account the above, it is therefore the opinion that till the next date, no steps may be taken for till the next date, a status quo be maintained as regards the possession of the land in question. Because I am not saying, I cannot say not to take because of the fact that if somebody else is in possession because he filed a suit.
Yes, yes.
So I mentioned as regards possession, status quo. Okay.
Obs-
But this will be only applicable qua you, the status quo. It can't be applicable for the other person.
Yes. Obliged.